to join our today's session, and kindly request to Dharam Singh sir to say few or
okay. Badhrinaryanan sir, our this today program live at our
You're saying something, sir?
sir. Okay.
Your voice broke in between, sir.
Sir, we can start now, and you can take any ask question from members, and member can ask question from our today guest speaker through chat box, question answer, and through our this audio mode also. We will open this audio mode. If you raise your hand, we will open this audio mode also, because we make our today's session is an interactive session. Because this we know this series will start with the exam oriented program, because this IBCC, this exam for insolvency profession. Sir Venkat sir and CA Badhrinaryanan sir, today we have a 5th day of program. Last 4 days we discussed the case study of different court level and our NCLT level, and I think latest amendment audience passed by government in 2021 already discussed in this our platform, and basic rule and regulation section up to section 1 to 28 already discussed in our panel. A liquidation plan and other things we will discuss later. Today I think our program on case study of Supreme Court, High Court and the other court also, because this case study may be long or lengthy. To make here this today's session is interactive through question answer may be very easily, sir. Vector sir, this today program moderator may be help to us for this make this webinar today interactive, sir.
Yeah, definitely.
Okay, sir. And now, sir, mic in your hand, Sri Badhrinaryanan sir, please, sir.
Right, sir. Thank you so much, sir. Me and Venkachalam sir, we are working together for a couple of years now, and we've been in this field only. So welcome to all the members. First of all, thanks, and I hope you are all safe, family is safe and healthy, and thanks for giving your time to attend this session. I hope that you gain good knowledge out of this, and this helps you in your exam attempt. So Venkat sir is a very senior company secretary, and we can say he's the first resolution professional to resolve a coal-based thermal power plant in Hyderabad. So he has that trump card to his name. So we'll start with the session, and how we are going to do it is, me and Venkat sir will take it half by half. So probably some case laws he will take up, some I'll take up. I'll ask his views, his questions, and we have made the slides in such a manner that all the 55 cases given in IBC syllabus, we have covered the summary here. So even if some cases are not covered in detail in the session, you can always go back, look at the slides, and it will help you in understanding what the crux of the case is. So normally in model questions, how they ask is it's a single line. You should know which case pertains to what subject matter, right? And once you know that, once you know, okay, innovative means it's related to directors, locus standi in filing a case once CRP is initiated. So once you know innovative, you know, okay, this is the subject matter of innovative. So similarly, once you go through all these case laws, go through a couple of times, you will get to know the subject matter, and when the exam question comes, it's an objective question, you'll be very easily able to correlate and choose the right answer, right? So before we proceed to take the case laws directly, I think first of all we should have some background about the topic and some insight on the role of judiciary. Then we'll go on and we'll understand the preamble, because for any interpretation of any act, first of all you should look at the preamble. You should understand the essence of the preamble, right? For constitution also we look at the preamble first. The basic structure, Keshavananda Bharati, you all know, the basic structure should not change. Similarly in IBC also you have a preamble. If you understand preamble, you will understand the object of the code, and that is how the courts also interpret the code. Then we'll go through some brief important provisions of the code, which you should know, because if you are new to this, if you don't know the sections, you will not be able to correlate the judgment, which will be hovering around the sections, right? So we'll take you along with, we have tabulated the important provisions. You can have a look at the provisions later on. Then we'll take you by the case laws, Supreme Court, High Court, NCLAT and NCLT. Then model questions, if time permits, we will show you how the previous year model questions have been framed up, right? So IBC is a very recent legislation, like it's like 5 years into being. 1st December 2016 it was brought into force. And even Companies Act, we had so many amendments which came in 2013, before that also. So it takes time for jurisprudence to evolve for a legal framework, right? And IBC is something, it's very new. There are a lot of gray areas, practical difficulties which are being faced by the professionals, by the coach, and all those practical difficulties are bringing forth the loopholes, you can say, or inefficiencies in the code. Now that is getting corrected by way of amendments, by way of precedents, circulars, notifications, right? So judiciary here plays the role of making the code much more effective by removing the gray areas and giving you interpretational clarity. When a code is new, when a law is new, there is always interpretation. People will want to interpret in a way which is convenient to them, right? And that is not the legislative intent. So the courts step in. If the government does not step in, the courts step in. They provide the clarity until and unless the time legislative amendments are brought in. So if you look at the framework of the code, the code itself has given institutional framework for implementation of the code, right? For any law to be successful, you should have adequate institutional framework to support the implementation of the law. If that is not there, then the law will obviously, it will fail. It cannot be a success. So the code also provides institutional framework. Suppose it provides the role of insolvency professionals. That is one institutional framework. Insolvency professionals are responsible for running the code. They are responsible for running the corporate data as a going concern. They have to ensure all the compliances of the corporate data. They have to constitute COC. They have to be a bridge between COC and the resolution applicant. Similarly, IBBI is there. That is the regulator. That is also an institutional framework. One important institutional framework is the adjudicating authority, right? Which means the NCLT, and there is appellate authority, which is NCLAT. Then you have Supreme Court. So if you look at IBC, landmark judgments have set the tone for IBC. NCLAT judgments have set the tone for amendments in IBC. There are a lot of cases where, because of NCLAT judgment, there have been amendments either to follow the judgment or to revisit and retune the code, right? Or to make ineffective the judgment, which the government might have felt it's not in accordance with the intent. Similarly, NCLT gives clarity on a lot of issues. Even now, after like 3 years, 4 years into this area, we still face confusion and practical difficulties in very small aspects. Like even for e-voting, you have to check what does the voting percentage. What about the people who have abstained from voting? How do you calculate voting for them? Does it mean they have said no to a resolution, or does it mean you have to exclude them from the denominator itself? So all these areas, they get clarity when this goes to a court, to a law forum, and the courts deliver a judgment that gets settled at NCLAT or Supreme Court level. That is how the jurisprudence is developed. So precedents, it's very important, not just for the exam, even when you become IP. These are some landmark judgments which will remain with you. You will have to use them again and again in your practical work as an IP, right? So Venki sir, he's a LLB also, he's a company secretary also, and he has decades, many three, 4 decades of experience. I'll just ask him his views on the changing dynamics of IBC, on how he has seen the changes, probably a short brief on how he looks at the judicial precedents. Venki sir, over to you. Sir, your mic.
Thank you, Badri. First, at the outset, let me thank the Institute of Chartered Accountants for giving me this opportunity. And I will do in the process of this 2-hour discussion, interactive discussion, justice to what we have been called for. Now, I have cleared this examination in the year 2017, and my first assignment was as an RP, not an IRP, but straight away as an RP. I was new to the subject, but I had a very organized team, efficient team in Badri and his colleagues, where we have handled two matters. One is a steel industry and the other one is a power industry. One is 2,500 crores exposure, debt exposure. Other is 6,500 crores exposure. And both we are proud to say that we have resolved them successfully. At that point of time, JSA law firm has told me that you are the only resolution professional in the country to have taken up back-to-back cases and both have resolved and not resulted in liquidation. Now, I also teach in CS institutes. I have started my own institute in Hyderabad. Students, before you become insolvency professional, you know the first requirement is to clear the limited insolvency examination. And for clearing insolvency examination or any examination, you need a strategy. And I, for one, believe that acronyms will help you in understanding and remembering the topics. Before I talk generally about the judiciary and its active role, I want all the students who are listening to me to note down. There is one famous saying of Confucius, Chinese philosopher in 300 BC. What he said is, I see, I remember. No, I hear, I forget. I see, I remember. I do, I understand. So as me and Badri talk to you, speak to you, you should note down in your notes so that it will permanently ingrained in your long-term memory. So the moment you talk, we are talking about an insolvency legislation. So you take the term insolvency as an acronym and we'll try to understand what all will fit in that. I stands for initiation of CIRP. I stands for initiation of CIRP, whether under section 7, 9 or 10 by financial creditor, operational creditor or by the corporate debtor. That is the first thing which I stands for. Then N stands for the two adjudicating authorities, adjudicating and appellate authorities, NCLT, National Company Law Tribunal and National Company Law Appellate Tribunal. And N also stands for nature and duties of IRP, interim resolution professional, who is appointed along with when the application of or any one of the applicants is admitted by NCLT, IRP is also appointed. That is, N stands for that. Then S stands for statutory documents to be prepared under CIRP. What are the statutory documents which IRP has to prepare? What a resolution professional has to prepare and what liquidator has to prepare. Okay. Then S also stands for secured creditors. So INS. Then comes O. O is obligations and powers of insolvency professionals. What are his duties under the code? What are his powers under the code? And O also stands for other creditors. Secured creditors and other creditors like workmen, you can have employees, etc. Then L stands for liquidation process. L stands for liquidation process. V stands for valuation. See, insolvency, I'm not giving it in the order of occurrence, but at least once you have these things in mind, that you know that these are the chapters which are covered. Now, the moment you talk about valuation, you should know that the code prescribes that you can appoint two valuers, and when there is a difference between them, you can go for a third valuer. There are several case laws when an IRP is appointing a third valuer without there is being any difference between two valuers. So valuation, V stands for valuation. And immediately regulation 35 should come into your mind, which deals with valuation. Then E stands for entrepreneurship. Ultimately, the goal of thing is to maximize the value of assets. You should use the entrepreneurial quality to maximize the value of assets. Then another N stands for nature and duties of resolution professional, which are more or less mentioned in the code, like IRP. RP also has certain nature and duties. Then C stands for CIRP, the entire process till section 32. What is from 12 to 32, you have the entire CRP process, which is for resolution. You have only two divisions, resolution and liquidation, right? Then last is yield or return of investment. So a resolution applicant, when he tries to invest in any company which is in CRP process, he will look what return on investment will he get. So that you should keep in mind and try to scout for resolution applicants. So this is what is insolvency. Why I told you insolvency in an abbreviated form is, so when you go to the exam, you know that what are the chapters which are covered insolvency, and you know what are all covered under that. Now coming to judiciary, as Badri told, the entire code is being reframed, redrafted, and revised, keeping in view the judgments made by NCLT, NCLAT, and Supreme Court. There are landmark judgments which we both will be discussing now. So you can say there is one sort of judicial activism with respect to IBC. But then the four pillars of IBC, that is the adjudicating authorities, appellate authorities, then insolvency professionals, then the information utilities, right? And COC. All pillars have to work in a coordinated manner for implementing the entire code. Now back to Badri.
Sure. So we'll start with the preamble, how to understand the preamble. We'll take it very quickly since we have to focus on the case laws. So the preamble to IBC says that it's an act to consolidate and amend the laws, right? Lot of laws existed before IBC came into the picture. So the intent of the government was there should be streamlined. These all laws should be streamlined so that there is faster recovery and faster resolution to stressed asset. So that is why it says consolidate and amend the laws. And relating to reorganization or insolvency resolution in a time-bound manner. That is the essence of IBC. All the resolution under IBC should be done in a time-bound manner. That gives certainty to the lenders as well as the borrowers. For maximization of value of assets, IBC tries to get you maximum value for the stressed asset. That is why we have Form G. That is why we have invitation for expression of interest. That is why we have multiple biddings. We have negotiations from the COC. To promote entrepreneurship. How does it promote entrepreneurship? When there is an exit opportunity given under a framework and with a certain timeline, entrepreneurs are motivated and incentivized to take risk and invest in a country, right? That increases the ease of doing business. That is how it increases entrepreneurship. Availability of credit. When you take off bad loans from the books of banks, the banks can give more credit outside. So that's how it develops availability of credit and balance the interest of all the stakeholders, including alteration in priority of government. So IBC tries to strike a balance between all the creditors, whether it's operational creditor, financial creditor, or your employees. It tries to strike a balance. It's not as if only the bankers will get recovery here. Order of priorities is tweaked because the intent was government is bringing in this law to help the borrowers and the bankers. So if government is standing first in line, it does not serve the purpose, right? So that's why the government said, I'll go down the line for the recovery, let other people take it first. And to establish an insolvency and bankruptcy board of India, which I told you is an institutional framework that regulates, that has the power to make regulations and issue circulars and also regulates the insolvency professionals. So this is what preamble is. If you understand this, most of the judgments, everything will touch upon the preamble and go. So this is what you should keep in mind. So these are certain slides which are given. You can always look at them later. This addresses each aspect of the preamble. Now look at the legal framework of IBC, right? So the purpose is always maintaining going concern, right? This was held in Swiss Ribbons judgment, and this was held in many other precedents also. The purpose is always to maintain going concern, and liquidation should be the last resort. You should never look at liquidation as the first resort. The broad process of IBC CRP process is given under Regulation 40A. And for liquidation, it's regulation 47 of liquidation regulations. So if you look at 48, it gives a model timeline that this is how the activities are supposed to be carried on. Similarly, for liquidation, regulation 47 gives the timeline. There is one case law which says that the stakeholders should try as best as possible to follow the model timelines. Then there are some important provisions of the code. So if you are new to this, there are some sections you should definitely know. So we have just tabulated those sections here for ease of reference. So section 4, this is insolvency and bankruptcy code, not the regulations. So section 4 of the code contains the applicability threshold, right? It was 1 lakh before, then it was increased to 1 crore because of COVID. And there's a pre-pack scheme for, for which the threshold is 10 lakh rupees. Section 7, 9, and 10 contains who can trigger an application. So it can be financial creditor, like banks who give loans and working capital. It can be an operational creditor, or it can be a corporate debtor voluntary thing. Section 12 contains your CRP timeline, which says 180 days is the 6 months timeline, and then it can be extended by 90 days, which is till 270, then another 90 days till 330. So this timeline, the government said it is mandatory that all litigations are also completed within this timeline, but the Supreme Court said that is not possible, and they said you can't make it mandatory. Litigations may take their own time, and that's against constitutional freedom. So they struck down that mandatory part. They said that this 330-day is directory and not mandatory. Yeah, section 14, which contains moratorium. There are a lot of case laws on this, right? Moratorium is given so that the resolution professional has a calm period wherein he can focus on the resolution of the asset and is not bombarded with litigations. And section 14 also states that licenses, permits, etc. given by the government should not be terminated. Then section 16 to 20 contains your appointment of IRP, public announcement, collation and verification of claims. I'm sure you must have gone through all this. Section 21 contains your voting rights. So normal items, 51% voting. Crucial items like related party approval or approval of resolution plan, replacement of RP, your interim finance, all these have to get 66% approval. 22, 23, 25 deals with the duties of IRP and RP. Then 27 talks about replacement of RP, which also needs 66%. Section 28 contains a list of matter which requires approval of COC. RP cannot do those things on its own. Section 29 contains information memorandum. On this also, there are some practical case laws which are not covered under your IBC syllabus, but it is always believed that RA is buying or bidding for an asset based on information memorandum. So in information memorandum, there is always a clause which says you are buying or bidding on as is basis, right? Tomorrow the RA cannot come and question that I did not do a due diligence. I believed on your information memorandum. You cheated me. So I'll pay you less money. All those things cannot happen. Then you have section 29A, which is very wide, that basically creates a bar on resolution applicants so that those persons who were responsible for this position of corporate debtor should not get the management again. Then 30 to 31, you have resolution plan approval. 30 is very important. It contains mandatory contents. Again, this section has been touched by various judgments on what is the role of NCLT and NCLAT. This is also judged by Maharashtra Seamless judgment. So it says that NCLT's role is limited to checking mandatory contents under section 30 subsection 2. They should not go into commercial wisdom of the COC. Then you have section 32A, which is very recent. So there was this Bushan, this is the Bushan seal followed, where after buying Bushan, Tata was bombarded with this ED attachment letters and all. And after that, Nirmala Sitharaman gave a speech in Lok Sabha, and she said that the new resolution applicants should be protected from prior offenses. So 32A was brought in. Any wrongdoing by the erstwhile promoter cannot be brought in on the new resolution applicant, so that new investor can start on a clean play. 33 contains your triggering of liquidation. If there is no resolution plan or it's a non-compliant plan, or the COC decides to liquidate, then it goes for liquidation. Then you have powers of liquidator, then you have what is liquidation estate. So liquidation, since it's covered in some other section, I will not talk on that here. Then you have section 43, 45, 50, 66. These are preferential transactions. So if there is a fraud which has happened before the CRP, it's RP's duty to find out if any fraud has happened and report it to NCLT. Then NCLT may take a call. If the fraud happened, then it may ask those persons who are responsible for the fraud to give back the money or the property. This is also important because there's a case of Anuj Jain which deals, I think that's the only case which deals in such a detailed manner on how an RP should conduct preferential transaction review. Then you have section 61, you have section 53, which is your order of priority of payment on how payment should be distributed in liquidation. Then you have section 61, which is inherent power of NCLT. NCLT uses this section a lot to entertain applications. Then you have the appeal section, section 62 and 3. Then you have penalties and other sections, not so important. 233 protects the RP. It says anything done in good faith, RP will not be responsible. 238 is very important. It is the overriding provision. Again, this you will find in many judgments. 238A also, at least 2 or 3 cases in our session will have a flavor of 238A. 238A talks about Limitation Act, whether Limitation Act will apply to IBC or not. So there are at least 2 cases in this session itself, which are covered under your syllabus. And 248, it's something for the MSMEs, saying that 29A will not be applicable for MSMEs and promoters can bid for MSME assets. Then you have some regulations, right? And I'll not dwell very deep into this regulation. So regulations are there for filing of claim form. It says how RP has to verify the claim form, how meeting should be conducted, how valuer should be appointed, right? And withdrawal of CARP. So it says when a withdrawal of CRP can be entertained by the COC. Then you have regulation 38, which is important. You read this with section 30 of the IBC. This also deals with mandatory contents of the plan, what a resolution plan should definitely contain. Then regulation 40 is there for extension of CRP. So section 12 read with regulation 40 for extension of CRP. Regulation 40A, I told you it's about model timeline. And then you have some liquidation regulation. We'll not go into that. So we'll start with apex court judgments, and me and Venki sir we will try to give more importance and more detailed picture on the apex court and the high court judgments, because NCLT and NCLT judgments, although very important, but there are more chances that you get cases on apex court and high court which are very recent, right? And NCLT cases which are given in syllabus might have been overturned also.
Badri sir, excuse me sir. Sir, ये full can you presentation in full screen?
I'll just do that, sir.
Yes, please.
Sir, in view mode, again we go to view and this last, this one. Okay.
Is this okay now?
No, it is not till click.
Now, okay, sir, but do one thing, show half page maybe. क्योंकि वो this बहुत कम दिख रहा है बहुत.
Wait, because
ठीक है सर, ठीक चल रहा है.
नहीं दिख रहा है क्या फुल स्क्रीन अभी?
नहीं दिख रहा.
क्योंकि जब YouTube पे कोई देखेगा तो बिल्कुल भी नहीं दिखेगा सर ये.
एक सेकंड सर, मैं देख रहा हूँ इसको कैसे क्या कर सकते हैं. मैं वापस एक बार शेयर करता हूँ सर.
Yeah, that's better.
सर एक काम करिए, इस PDF का परसेंटेज बढ़ा लीजिए, इसको 150% कर लीजिए आप.
हाँ.
Now okay.
It's okay.
Now okay, sir.
Now it's looks very big to me. Okay. So we'll give more time to apex court judgments because that is more important, and that will help you going forward also. And anyways, we have given all the judgments we have covered. So even if something is left, you can always just go check the site. I've just given the crux, which will be important for you to learn and give it in the exam, because in exam they will just ask you, this is the subject matter, which case does this relate to, or dash case this was held, right? So it's easy that you just read the crux and you'll able to answer it. So the first case, and me and Venki sir will just distribute the cases. I'll just ask him his views in between. He will take some cases. So the first case we have, this is the first landmark judgment of the Supreme Court. This is Inventive Industries case, Inventive Industries versus ICICI Bank. So prima facie, what happened here is the directors had some problem in the corporate insolvency resolution process. The promoters had some problem and they intervened and they filed a case. They wanted to stop the process, right? So in Innovative Industries case, there are three things which came up. One is your Maharashtra Relief Undertaking Act, right? There was a question whether Maharashtra Relief Undertaking Act will have a upper ranking than the IBC, right? And it also wanted to get into the question whether directors who have been suspended because of institution of CRP, do they have any locus standi to file a case on behalf of the corporate debtor? So because this was very crucial and this was the very beginning of IBC, right? And there was a lot of expectations from this case because what was happening is already the timeline was getting diluted. So there was a 180-day timeline, and because of all these litigations, these timelines were getting pushed, right? People were operational debtor were filing something, directors were filing something, promoter had some grudge, he was filing something. So all these things were leading to delay in the 180-day thing, and the object of the code was being lost. So Innoventive was the first major landmark case given by the Apex Court. And here the Apex Court said, according to us, once an IP is appointed to manage the company, the erstwhile directors who are no longer in management obviously cannot maintain an appeal on behalf of company. That means company is a sole appellant. It has to be represented by the RP. Once the RP is in picture, the erstwhile management or the directors, they don't have any say in the company, right? And the court also said that the IBC, from because of IBC, the framework has moved from debtor in possession model. In Surface Act or other acts of resolution which you had before IBC, it was always a debtor in possession model. You did not have creditor in control. But here the court very finely brought out that there is a dynamic shift in the way resolution is being done in our country. That shift is it's moving from debtor in possession model to creditor in control model. So that was brought, and it was told that because there is this dynamic shift, now everything is in the hands of the COC for whom the RP is working. So now the directors or ex-management do not have any power or any right to appear for the corporate debtor because of their fault. The corporate debtor has gone into stress and IBC has started against them, right? So now only the RP can represent the corporate debtor. So the Supreme Court interestingly even told the directors said, we want to modify the cost title. We will not represent the corporate debtor. We will represent as an aggrieved person. Right? Now the Supreme Court even dismissed that as well. They said you cannot represent in any manner whatsoever. Then we have the Mobilox Innovation Private Limited case. Mobilox versus Kiruso Software Private Limited. Venki sir, would you like to take this? This is on the definition of dispute and existence of dispute, sir.
Yeah, see, for initiating any application against the corporate debtor, first of all, existence of a dispute is very important. Okay, but suppose if in the agreement there is an arbitration clause in one of the clauses, so any dispute first should be resolved by the arbitration, and then only they can come to the IBC. So they want to arbitration is a special law. Normally, special law prevails over a general law. Even though IBC under section 238 and all that, it overrides all other laws. What they decided is, once if there is a dispute can be proved, application can be filed. But supposing there is a clause in the agreement that there is an arbitration agreement and that has to be referred to. So Supreme Court, they made an saying, only if a suit or an arbitration proceeding on the dispute is pending before receipt of demand notice, then that should be utilized. That is one of the highlights of Supreme Court judgment. And then they also stated that in case of a dispute that arises a few days before triggering of the CRP, there would be no time to approach either an arbitral tribunal or a court, even though a dispute may exist. That is one observation they made. And what is important is the existence of the dispute and or the suit or arbitration process must be pre-existing. It must exist before the receipt of the demand notice. Then arbitration proceeding, otherwise the application will be allowed. Okay.
I'll just like to add one more
yeah.
point here, sir.
Yeah.
So here the Supreme Court really went very deep into defining what dispute is and what is the existence of dispute. Because for an operational Freitas application, the entire application depends on whether the dispute is there or not. Because if dispute is there, straight away NCLT will reject the application. So here the Supreme Court defined what is dispute, right? And they said that only if you read the court says if anything is pending in a court or an arbitral forum, then it's a dispute. Supreme Court said no. See, there can be some disputes for which I could not, it came just one day before CRP and I could not approach the court or arbitral tribunal. Does that mean there is no dispute? So the Supreme Court said even this is called dispute. And what is existence of dispute? Supreme Court says that suppose there is any breach of contract as well, any breach of warranty or representations, even that is dispute. This is inclusive definition, right? So the Supreme Court is saying the only duty of NCLT is to check whether there is a spurious claim on dispute, right? An operational data, the first defense he will take in any case filed against him. So a corporate debtor is there, an operational debtor has filed a case for CRP. A corporate debtor, the first defense he will take in the Section 9 application is there exists a dispute. If that defense is genuine, NCLT will reject it. So the NCLT's role here to check if that statement is genuine or not. Is that a spurious claim? Is that a claim made just to get this case dismissed? If that is satisfied, the NCLT is not authorized to go into the merits of the dispute. It need not go into whether really that dispute existed or not, what agreements were there. No. If this is not a spurious claim, simply NCLT has to reject the application. Am I correct, sir?
Yeah, that's what. See,
sir, may I conclude this? This case. So, meaning thereby, I think legislation passed by any government, central government, would prevail.
Sorry, sir.
We didn't get you, sir.
Can you repeat, sir? Hello.
No.
Can you repeat, sir?
No, not at all.
All right.
So if the dispute is spurious, just created for the sake of it, then NCLT will admit the matter. If that is a dispute is genuine and is appearing, then it has to be resolved by the arbitration or whatever resort they have to.
Yes. There are some other case laws on how Arbitration or Limitation Act applies to IBC. That's also there. We have some High Court judgments, some NCLAT judgments. That's also there. So we'll move on to the next case now. So the next case is Shivam Water Treaters Private Limited versus Union of India, Secretary to Government of. So this was a challenge to constitutionality on the ground of discrimination against operational creditor. So what the petitioner here said is the operational creditor does not get any say in the COC meetings, right? The operational creditor is not given any power, and the operational creditor is given only liquidation value in certain cases. And this code is very discriminatory to the operational creditor, and this is against the principles of natural justice. So lot of petitions were coming which were wanting to quash the IBC and wanting to challenge the grounds and the constitutionality of IBC. The Supreme Court wanted to put a stop to all these petitions because just now a code has been framed, right? Something good is happening. Stress doesn't have to be resolved. And certainly there are so many petitions which are directly challenging the constitutionality itself, and they are not letting the code to work. If you don't let it work, how will you find out whether it's efficient or not, right? So the Supreme Court wanted to put a stop to all these petitions, and then all this was brought before in the Shivam water treatment case as well. So here I've just highlighted the important things which you should read for the exam. I'll just go to the conclusion directly here.
Basically, Badri,
Yeah.
Under the Constitution, classification has to be based on intelligible differential. What they challenged was they have unnecessarily differentiated between operational creditors and other financial creditors, and they were not differentiated between secured creditors and unsecured financial creditors. So there's a lot of constitutional invalidity is there. They challenged, but
Right.
what Supreme Court has finally said is the differentiation is based on intelligible differential. That Turquand case, Royal British Turquand is there. That also, which was in the constitutional law, was upheld, and they said that classification was proper. And operational creditors under section 24, they have given an opportunity. If their debt is more than 10% of the total debt, they also can be member of the COC.
Right. So it's not as if that they have not been given any role to play. So what this judgment also says is only marginal players have been removed. So if you have a big operational creditor whose debt is more than 10%, he'll get to visit the COC, he'll get to sit in the COC, he'll not be given a voting right. Now, that there is also a logic for that. What the court says, what the Banking Law Reforms Committee says. So I forgot to tell the audience. Also, please read Banking Law Reforms Committee report because that is the foundation of IBC, right? Any major case which goes to the Supreme Court or even NCLT, NCLAT, it is always, the court always goes back to BLRC report. Like for Constitution, if we have any confusion on interpretation, we always used to see the Constitutional Assembly debates, right? That brings forth the intention of legislator. So like that here also, you have to read the BLRC report. You have to read the Insolvency Law Committee report, because those are the basic foundation. Based on that, whatever they thought, the people framing the law thought, it's all visible there, right? So here also, BLRC report gave a particular role to operation creditor, right? It understood that operation creditor is somebody who's supplying goods and services to the corporate debtor. Financial creditor is somebody who has been there for the corporate debtor for a longer part of time, infused a very substantial amount of money, and is more interested in the working of the corporate debtor and plays a nursing role to the corporate debtor. So financial creditor, and normally they are large institutional investors, right, or lenders. So they will have, and they, before giving loans, they will have done a very good due diligence, which operational creditor of a small value could not have given or could not have done. So financial creditors, that's why, are placed in a better position to take commercial calls for the corporate debtor undergoing CRP. So that's why the court here said that there is a very reasonable differential there for the classification which is done between creditors, and it is not unconstitutional, and there is no violation of principles of natural justice. So if the exam asks you, it may say which was the case where the operational creditor brought up about the discrimination between creditors and challenged constitutional
validity.
Yeah. So you should know that it's a Shivam water treater case, right? Which was the case where many batch petitions were filed in High Court for getting the IBC quashed. This is one of the first cases where the constitutionality of IBC was upheld. Swiss ribbons came much later. Then you have this BK Educational Services case, right? So this is a major case relating to application of Limitation Act. So what basically the Supreme Court held here is, it doesn't matter, or it's not relevant as to when the IBC started operation. So 1st December 2016 is when the IBC was started operation. So the court said it's not relevant for seeing the applicability of Limitation Act. It's not relevant to see when the IBC started, right? And it gave a lot of reasons why it's not relevant. So we'll just look at some of the reasons.
Yeah, basically what they're trying to say, that if any debt is time barred already, okay, prior to this law coming into force, that Limitation Act still applies, and they cannot take advantage of IBC and rake up again the whole issue.
Right. So the Supreme Court said if something is time barred, like sir said, if something is time barred, you cannot come and you cannot put that into IBC. So the Supreme Court also said that 238A is a section which talks about applicability of Limitation Act. Right? So the Supreme Court also says amendment of 238A would not serve its object unless it is construed as being retrospective. Otherwise, applications seeking to resurrect time barred claims would have to be allowed, not governed by law of limitation. So, if you don't make 238A retrospective, the entire object will fail, and all the time barred debts will come here and file cases, right? So that will insult the Limitation Act as well. It also said that it is clear from reference to Insolvency Law Committee report. This is what I'm saying. Any major judgment you read or any, it's always better to read the bare act and the bare judgment, right? Because interpretational issues will be there. I'll interpret in a manner very different from you will do, but it's always better that you read from the bare act or the bare judgment. Here also there is a reference to Insolvency Law Committee report. Any big judgment you read, there will be a reference to some committee report. Either it will be BLRC report, Bankruptcy Law Committee report, or ILC report, first ILC report, second ILC report, subcommittee of ILC report. The courts themselves, they go into these reports to find out what the intent of legislator was, what they wanted to do here, why 238 was brought in, right? So it's always important you read those also, not just for the exams, but for your work as IP in the future.
So
It also
they,
said,
in this matter, they have to remember 238A of IBC
IBC,
and
IBC.
section 137 of Limitation Act,
Yes.
which says 3 years is for other matters.
Right.
Is the time period. Yeah.
Section
So,
137, sir, or article, I think it's article 137, sir.
No, but Limitation Act means sections only, no?
Okay. So the court also said that there's a reference to ILC report that the legislator did not contemplate enabling a creditor who has allowed period of limitation to set in to allow such delayed claims. What it means is the legislator did not want that people who have let limitation time period pass, who have let their debt be time barred, the legislator did not want those guys to come and file a case here. That was not the intention of introducing 238A. It also says, like section 433 in the Companies Act, this will also be there from the inception. Then the expression debt due in definition section of IBC, that is, it says that has been interpreted by various Supreme Court judgment, and it means debt due means due unpayable, right? So if something is time barred, it is not payable. So this is again one more reference to saying that
Correct.
IBC has nothing to do with law of limitation, right? The 3-year period will not count from the initiation of insolvency and bankruptcy code. There is no relevance in between these two. If a debt has become time barred, you cannot come and trigger IBC case here. It also says that since the Limitation Act is applicable to application filed under section 7(9), 7 is financial creditor, 9 is your operational creditor. Since the Limitation Act is applicable to application filed under 7 or 9 of IBC from inception of IBC, section 137 of the Limitation Act gets attracted. This is section, sorry, there's a misprint. Section 137 provides period of limitation for other cases 3 years from the time when the right to apply accrues. So here, what is the right to apply in IBC case? If a default occurs, so that is the right to sue. So within 3 years of default, you can trigger an IBC. If that has passed away, then it is time barred and you cannot approach under IBC. If default has occurred over 3 years prior to date of filing, application would be barred under section 137 of Limitation Act, except where continuation of delay has been provided under section 5. The rights, anything else you want to add, sir?
No, that is the main thing. See, what I prefer, ask the students to remember is, in each case law, whatever section is there and other enactments, whatever provisions, that they have to note down and try to remember. Because a question can be twisted and put it in a different manner. But once they understand these provisions thoroughly, it will be easy for them.
Right. Then we have Chitra Sharma versus Union of India. So this case is something which came as a relief to home buyers. So home buyers were not considered financial creditors earlier, right? Who are home buyers? Home buyers are allottees. I'm a buyer. I went to a real estate developer. He was building a project, and I wanted to book a flat in his project. I booked a flat. I paid him some money. Some money spending from my part. That guy is yet to complete the construction or give over the possession. So, what is my status as a home buyer if that builder goes into insolvency? There was no clarity on this. So, Chitra Sharma versus Union of India gave clarity on this, right? It said that you have to treat home buyers as financial creditors. Here, what happened is you have this JP Infratech, it's a very big group, and JP Infratech was pushed into IBC, right? And the parent entity, JAL, Jayaprakash Associate Limited, they want to give a resolution plan here. They started telling the lenders that you give back the management to us, we will complete the project, we'll deliver the flats. But even before 29A came in, the Supreme Court said that cannot happen. You are responsible for the state of this company. You are barred from again taking the company. This is a creditor in control model. So the RP will be taking care of the affairs. Right? So I've given brief background here. So it says the main grievance was despite being vital stakeholders. So the home buyers, they told in Supreme Court that we are the allottees. It's our money that's going in indirectly and is able to build those flats and sell those flats at a profit. And we are not given a role in this IBC process, right? Somebody's putting something in the chat. Good evening. Good evening. So the home buyers had this grievance, and they said that you give some role at least in the CRP. There should be some role in the CRP so that our interest is taken care. Ultimately, when the flat is made, it is going to be delivered to us, and we are the one paying the money. So we are not having any locus. That's why the provisions of IBC should be declared ultra vires. They wanted equal status as financial creditors. Now, what was happening is because of this stand of home buyers, NCL Supreme Court had stayed the CRP process, but then the RP told Supreme Court that if you stay the CRP process, it is going to harm the maximization of value. It's not going to get anything to anybody. You cannot give back the management to the promoter. If I don't start the process, I cannot get investors. It will stop the process. Home buyers will be affected more if you stop the process. So the Supreme Court vacated the stay. They directed the RP to continue over management of JP Infratech. They also, to ensure that home buyers are protected, Supreme Court nominated one senior counsel to represent the home buyers in committee of creditors. Then IBBI came up with Form F, which said that home buyers have to file Form F, which is other than financial and operational creditor, right? Over the proceedings, the parent entity made several attempts to try and take back the management or to give a resolution plan, and they were set away. Also, RBI wanted to file an application against the parent entity itself because of the stress in parent entity, which the Supreme Court had allowed in this case. So several resolution applicants gave a resolution plan. Even the parent entity gave, and it was rejected because they were, then 29A also came, then JL was rejected because they were barred under section 29A, right? Then an ordinance was brought in by the government which said that home buyers are financial creditors, and it was allowed for them to trigger section 7 cases. So now even home buyers, because they are financial creditor, they can trigger application of CRP under section 7.
But minimum 100 should move the deputation. Yeah.
So minimum 100 home buyers should come together and they can file a case.
Or 10% of the total.
10%. So the Supreme Court passed significant directions. So what happened is because of all these litigations, all this process happening, the time ran out. The CRP time ran out. And this is a very unique case where the Supreme Court, in the interest of home buyers, right, and in the interest of stakeholders, it started the CRP process afresh. It recommenced the CRP. It directed that the Form G be reissued so that more investors can come. And it also said that the home buyers will be financial creditors. They will have the right to sit and vote in the COC, right?
So they revived the 180-day period again.
Yes, they revived the 180 days. That has not happened anywhere else. except for the Jet Airways case where some extension had been given. But apart from that, revival of CRP is something I have not seen. The court also agreed to RBI to initiate a CRP against the parent entity. Then you have Sagar Sharma versus Phoenix ARC. So it's a very
I think Limitation Act only.
again. So like I said, we have a couple of cases on Limitation Act. BK Educational Services is the major case law we should all remember. Right here, the NCLAT, while dealing with limitation, dealt with commencement of code as a relevant trigger. Again, NCLAT says commencement of code is linked to application of Limitation Act, which is what exactly opposite was told by Supreme Court in BK Educational. BK Educational Supreme Court said there is no relevance to commencement date of the code vis-a-vis application of Limitation Act, right? So here NCLAT said there is a relevance, and they put the petition under section 162 of Limitation Act, and they said there was a deed of mortgage, and they linked it to the deed of mortgage. So citing BK Educational Services Parag Gupta, which you already discussed, the Supreme Court said this is wholly irrelevant to triggering of limitation period for purpose of code. You do not go and look into commencement of code because you are wasting your time here. We have already laid down in BK Educational Services that this is irrelevant, right? What is irrelevant is occurrence of default. If default has occurred under IBC for a Section 7 application, only relevant thing is occurrence of default. If there is a default, a financial creditor can file a case. Which percentage, ma'am? Pallavi, Miss Pallavi?
Yeah.
I think you can switch on the mic and ask the question. Okay. So here the only relevant point is there should be a default. If default is there, Section 7 can be filed.
Is she talking about home buyers ka 10%? I don't know. Anyway.
Maybe, sir, maybe. Home buyer,
100%, yeah, 10%.
100 home buyer or 10% of the debt of home buyers. So
Yeah.
these people should come together and file a Section 7.
Whichever is less.
Yes. I hope that's clear, Pallavi. And here the Supreme Court also said you don't go into Section 162. That's not applicable. You have to be governed by Section 137 of Limitation Act, which talks about the 3 years period. Then you have K. Kishan versus Vijayanam Company, right? So here the Supreme Court had occasion to decide whether IBC can be invoked in respect of operational debt, where arbitral award has been passed in favor of operational creditor, right? So here what basically Supreme Court said is if something is pending in an arbitral forum, if some appeal, some dispute, something is pending in a forum, then that will stop you from triggering IBC. Then I'll just take down to
Ex-employee.
yeah, State Bank of India versus Veterinary Limited. So this is a very recent case. What happened is NCLT there was a case filed by SBI for initiation of CRP where SBI appointed an ex-employee as its resolution professional, and this was said that NCLT denied him, saying that this should not be done. NCLAT also upheld that, saying that there is a conflict of interest and that should not have happened. This went into Supreme Court, right? Because the insolvency professional's reputation was also at stake here. The Supreme Court said that the logic of NCLAT was not good in law. Just because some person was an ex-employee a lot of years back does not mean he will do something prejudicial to other stakeholders, right? So it said that the stand of NCLAT is wrong. And it also said that, okay, because in this time replacement of RP was suggested, SBI also had agreed, so that they are going to replace the RP anyways. Supreme Court said, although they are going to replace the RP, because of this judgment, yeah, nothing adverse should go against the resolution professional.
Yeah, as Badri, but
Yes.
still you know that many banks, they are not following this. That is, ex-employees, they are not taking because of conflict of interest.
Correct.
IDBI and other banks.
It runs into trouble with the other lenders.
Yeah.
Then you have this case of Dharni Sugars Chemical versus Union of India. So I picked up some summaries IBBA gives out in a very fantastic form, right? They are doing really a good job on summarizing this 200-300 pages judgment. It's very difficult to tune it down and bring it in a crux format for us readers. But IBBA has been continuously from the beginning. If you go to IBBA site, you can find all the Supreme Court judgments, at least you can find in the summarized form. So I've taken out from them because since it's uploaded on IBBA made by them, more chances of them picking up questions from these liners, right? So in Dharni Sugars and Chemicals Limited, there was a 12th February 2018 circular issued by RBI, which says that any stressed account more than 2000 crores exposure, right? Even a single day default in those accounts, RBI will direct the banks to proceed under insolvency against those borrowers. This brought out a lot of controversies. A lot of people went against this. That how can one day delay can make RBI or to direct banks to initiate CRP process against us. There can be multiple reasons for a company to go into stress, which can be out of the control of company. It can be environmental licenses, can be some approvals, land approvals. So specifically for power sector was struggling a lot, and this really disturbed the economy, disturbed the industry as well. So a case was filed to quash the circular and also quash the regulation 35 AA and AB was brought in here. So it was filed to challenge the constitutionality of this validity of this regulation. So what basically here Supreme Court said that these inserted regulations, these provisions which give RBI certain regulatory powers, they cannot be said to be arbitrary. So Supreme Court says it's not arbitrary. The regulations are okay, right? They say that Section 35 AA and AB are constitutionally valid. It says that a cursory reading of 35A makes it clear that there is nothing in the provision which would indicate that the power of RBI to give direction when it comes to insolvency cannot be so given. It says that nothing there in Section 35A stops the RBI from giving some direction in relation to insolvency and bankruptcy code. If a specific provision of Banking Regulation Act makes it clear that RBI has a specific power to direct banks to move under code against debtors, which are borrowers, in certain specified circumstances, it cannot be said that they would be acting outside the four corners of law, right? So again, the court is saying whatever RBI brought in the circular, it's not in violation of law here. It can be done. Then therefore, one important aspect which Supreme Court brought down here was, as per Section 35 AA, it says authorization from central government is prerequisite for RBI to issue such direction. Without getting authorization from central government, RBI cannot issue these kind of directions. It says prior to enactment of Section 35 AA, it may have been possible for RBI to issue such direction. But after 35 AA come, such direction could be issued only within four corners of 35 AA. Again, it's talking about four corners, right? When once 35 AA came, it says RBI had to seek authorization from central government to issue such circulars. RBI can only direct banking institution to move under the code. We are talking about insolvency. So it can direct banks to move under the code only if two conditions are there. Condition precedents are there. One, there is a central government authorization to do so. Second, it should be in respect of specific default. What it means is there cannot be a general circular saying that whoever comes under the circular, you move under IBC. It says it should be case by case. The words under the section without prejudice, it's highlighting the fact that these powers are only illustrative. So there is no restriction for the RBI. Again, supporting the RBI, but it's saying it should have taken authorization from government before issuing such circulars. Then it says when it comes to issuing direction to initiate insolvency process under 35 AA, under the code, 35 AA is the only source of power. So if it wants to give direction to banks, RBI wants to give direction to bank to initiate insolvency process under the code, 35 AA is the only source, and 35 AA says you seek authorization from central government. when it comes to issuing direction in respect of stressed asset, right, other than coming under the code, then it falls under 35A read with 35AB, not 35AA. It says that the stress asset can be resolved either through the code or otherwise. So you used to have joint lending forum, you used to have a G4A, restructuring processes, right? S3A, and you have the code. So it says one specific section is for the code and 35A and 35B is for other processes. So whatever is given in the law, RBI should follow the law. So 35A says without authorization from government, don't issue circular. So RBI should follow that law. Then it says what is important, that it is a particular default of a particular debtor. As I said, specific defaults, right? Any direction which are in respect of debtor generally would be ultra vires section 35AA. So here you cannot issue one circular and push everybody into insolvency. Then it said that it's very difficult to segregate NBFCs and banks. They most likely fall in the same criteria. So this applies to NBFCs also. In view of the above, the impugned circular is ultra vires and has no effect in law because RBI did not take any authorization from central government and there was no authorization for specific default. Consequently, all actions taken under the said circular, including actions by which code has been triggered, must fall. So everything 0. As a result, all cases where debtors have been proceeded against under section 7 only because of this circular are non-est. So lot of CRP started because of this circular. And after this judgment came, all the CRPs were made void. Venki sir, anything you want to add?
Yeah, that's what. But whatever you said is sufficient. See, this that RBI with the central government's permission, they can issue directions for specific defaults, and that is not ultra vires. But whatever generally they give, that will be, because it will be multiplicity of litigation then.
Correct. Then we move on to pioneer urban land. This for home buyers, if you want landmark judgments, one is the Chitra Sharma case, which we studied, the first case, right? Then you have pioneer urban land. This dealt with other issues also, but this was mainly relating to home buyers. So pioneer urban, in that Supreme Court said that when it's a piece of economic legislation, like IBC is a piece of economic legislation. So the court said that NCLT and NCLAT should give some kind of deference for the process to work. If the courts are very judicially active and they get involved in each and every nitty-gritty of the process, an economic legislation cannot fly. So the court should give some freeway to for the framework to work. Then it said that home buyers were already made financial creditor, right? To clarify that home buyers are treated as financial creditor so that they can trigger the code under section 7 and have the rightful place under COC where it comes to making important decisions. So for the Insolvency Code Second Amendment Act 2018, which classified home buyers as financial creditors, that was challenged. So this case law put an end to that challenge by saying that right has been done by bringing in the amendment. A section of society which was getting wrong done against it, that wrong has been rectified. So there is nothing wrong here. So then it was challenged, how do home buyers fall under financial debt? Then Supreme Court said section 5 subsection 8 clause F is there. So Supreme Court said there is a time value of money involved in this case because an allotee is paying money and he's going to get his flat after a long time and he's giving consideration, right? So there is time value of money involved and home buyers will be financial creditor under section 5 subsection 8 clause F. And there is no need for even going into the explanation because it falls squarely under 5.8F. So a question in the exam may ask which section that the pioneer judgment say home buyers will fall under as financial debt. You should say 5.8F. Or which case it was held that home buyers debt is financial debt under section 5.8F. You should know it's pioneer. So you should be able to choose the right answer from there. Then the pioneer urban case also talked about RERA versus IBC. Everybody here knows RERA. It was a specific act to bring relief to home buyer. If builder is not doing something right, you can approach the RERA authority and you can gain some compensation, file a complaint against him. So here a question was, will RERA overtake IBC? Which will prevail, RERA or IBC? So the Supreme Court said if you can read it harmoniously, but RERA will not prevail over IBC. If there are any contradiction or conflict between RERA and IBC, RERA should give way to IBC. Then there are remedies for home buyers. So home buyers can go to RERA, they can go to Consumer Protection Act, they can, so they have multiple remedies, they can come under the code as well to trigger insolvency. Again, the constitutionality of IBC. So the code said the object of the code are subserved by treating allottees as financial creditor. The Amendment Act does not infringe Article 14, 19(1)(g), 19(6) or 300A. 300A is your right to property. So these things are not violated by this amendment. And it was challenged that many home buyers, just to take out their money, they might file case against big promoters and push them into insolvency. So the Supreme Court said, boss, builders are very big people, and if home buyers is triggering insolvency as a default, if they say it's a default and I'm triggering insolvency, it's upon the promoter to prove that the home buyers are doing it in a speculative manner or in a fraudulent manner, right? And there are a lot of steps which will stop the home buyers from doing that. They will lose their flat, they will lose their money. So it's a very far-fetched idea that home buyer will be trigger happy. Trigger happy means, okay, I have the power to trigger insolvency, I'll trigger and I'll take my money. So Supreme Court said, don't have such far-fetched ideas that this will be the result of this amendment. Also, some directions were given to appoint RERA authorities in each state because it was not done. Then you have ArcelorMittal case, very important case, right? This is related to SR Steel. Here, questions were raised on section 29A, right? So the court said purposeful and contextual interpretation is imperative to find out real individuals. So it's not just that you read the law and you just make a monotonous checklist and okay, tick karke, okay, this person is not in 29A. No, you have to, like, you pierce the corporate wheel to find out somebody behind the company, right? So here also you have to pierce the corporate wheel and find out the connected person. So it says that it is very imperative to find out real individuals or entities who are acting jointly or in concert. It may happen the promoter has a back-ended entity or some friend, right, through whom he used to have business transaction. He, because he is bad under 29A, he might bring some other entity and front end that entity. So it's very important for an RP or for the COC to check 29A in a very substantial manner and to make sure that these kind of loopholes are not used. A lot of discussions on 29A was there, right? And it says, what is the meaning of acting in concert? It says, court said it includes any understanding, if it is in, even if it is informal, even if it is indirect, to exercise control over a target company. And it depends on the facts of each case. So there is also a clause which says that people who are NPA, they can bid for an asset if they pay, they can give a resolution plan if they pay everything before submission of plan. So if they clear off their NPA before submission of plan. So there was a question about the timeline. So does this section start when the CRP process starts, or this has to be seen at the time of giving of resolution plan? The court says that it's very clear at the time of submission of resolution plan by the applicant, you have to see whether the individual is eligible under section 29. 29A, it detailedly dealt with, right? It was asked, how can ineligibility be removed if there is an NPA? So the court said, pay all the amount before giving a resolution plan. It will be removed. That's there in the code anyways. Purpose of provision was explained. It says that those who are in charge of corporate data do not come back in some other form to regain control. This is what NCLAT also had many times. Those people who are responsible for the stress in the corporate data should not get control of the corporate data again. Then it spoke about SEBI. If SEBI has barred somebody from trading, they're also ineligible. But this ineligibility cannot be cured by paying off the debt. So a lot of queries were raised on 29A because it's a very vast section. A lot of queries were raised. What if this happens? What if that happens? So Supreme Court has dealt with all those queries in this case law, right? It says, does a prohibition similar to clause F, right? So whatever is explained in A to E about an Indian citizen. So anybody who's outside the country who wants to bid for the resolution corporate debtor. So does these prohibition make him also ineligible? It said yes. Court said yes. Then section 12 timeline was discussed, right? So it was said whether the timeline is mandatory. So section 12 180-day timeline. So the court said it is mandatory. Timeline is the essence of this code. If the timeline is not mandatory, the process will keep on going and we cannot get success out of the code. It said whether 180 days can be extended. So that time it was extended up to 270 days. So court said yes. But it also said that it should be endeavored that it is completed within 180 days. Regulation 48 contains your model timeline under CRP regulations. Court said it is suggested that all people follow regulation 48. It's not mandatory, but suggested to follow. Section 30, subsection 2, mandatory contents. So here it was asked is, if RP rejected a resolution plan given by an RA, can RA challenge that in court? So here the court said RA right now has no vested interest. He gave a plan to RP. RP checked mandatory content, and it has rejected he has rejected to place it before the COC. Only when the COC has discussed on the plan, deliberated and voted on it, can there be a right for the RA to approach NCLT. Till then, there are no rights accruing to the RA, and he cannot approach NCLT. When is a resolution applicant aggrieved? An applicant can approach NCLT for relief only after a plan has been considered by COC after voting. Only then can resolution applicant be aggrieved and he can approach NCLT. Then it also spoke about the role of resolution professional. So here it says that, see, resolution professional will examine the plan, he will check if mandatory contents are there. He is not required to take any decision, right? He will probably check it and tell the COC. COC will say when it's not compliant with law, don't place it before us. Even for 29A, you cannot hold the resolution professional responsible if the resolution applicant has hidden something from him. His duty is he can probably engage a 29A reviewer, right? He can take an affidavit from the resolution applicant, but you cannot expect him to do a very detailed due diligence on that. Then it also speaks about the role of Committee of Freitas. It says the Committee of Freitas has to approve or disapprove a plan. RP has no role in approval or disapproval. So committee approves or disapproves the plan. It says that if the Committee of Freitas rejects a resolution plan, right? Or it says that there is some ineligibility under 29A, then it is that discretion is there with NCLT and NCLAT to take up those cases and really find out whether that rejection was arbitrary or the rejection was good in law. It also says that if the plan is approved, it can be challenged in NCLT, NCLAT. Sorry, it can be challenged in NCLAT and then in Supreme Court. Scope of interference by NCLT. Court said that it does not invest the NCLT with jurisdiction to interfere at applicants' ways at a stage before quasi judicial determination by NCLT. So this means that before any judicial determination has been made, there is no point of bringing in new application and delaying the processes. This is what was happening initially. Everybody was filing application and delaying the CRP process. And on the timeline for NCLT, because a lot of time was taken by NCLT also to approve the plan and hear the matter, the Supreme Court said that we cannot, looking at the backlog of cases and how the infrastructure is, we cannot put much pressure on them. But it's not that NCLT and NCLAT should delay the hearing indeterminately. It also said the time period in litigation should be excluded in the CRP process. So this was a very big judgment. If you look at the original judgment of that SR Steel, it would be running into 250 pages, right? But they have made it into a very specific, concise manner for us to read. Then again, COC SR India versus Satish Kumar Gupta, right? Here in this judgment, the validity of IBC Amendment Act 2019 was upheld. So again and again, whenever some amendment act came, somebody filed a case in court challenging the constitutionality. and the Supreme Court has decided on those matters. Here also role of resolution professional was discussed, what he should do, right? So he should manage the affairs, run it as a going concern. He should facilitate the COC to make decisions. So it said the role is administrative and not adjudicatory. And what is the role of prospective resolution applicant? So court said he should have all the information about the corporate data. So he should give a good resolution plan, right? He should provide for all measures in resolution plan for maximization of asset. So all those things the court gave out a clear picture here. It also said that the resolution plan must provide amount due to OC shall be given in priority, right? Amount due to financial data, there should be a balance which should be struck between all the stakeholders. So it said that it's a responsibility of resolution applicant to ensure that his resolution plan balances the interest of all stakeholders. Let's talk about role of COC. So here all the roles were discussed: RP, COC, RA, adjudicating authority. So it said that it's the commercial wisdom of COC to decide whether or not to revive the data. So if it decides to liquidate, it's its commercial decision. No, nobody should interfere in that.
Here, 1 second, Badri.
Yes, sir. Yes, sir.
Whatever is to be paid to operational creditors, why don't you tell about that? What is the amount? Agreed priority is there to operational creditors.
Yes,
or
okay,
financial.
okay.
But how much has to be paid to them?
Yes. So as per law, you should give at least liquidation value to operational creditor and dissenting financial creditor. Liquidation value which should not be less than what they would have got under section 53. Exactly. So section 53 has your order of priority where the secured creditors get the money first, employees get it along with them, right? So in practical cases, what we see is when this interpretation is taken, operational creditor will normally get zero because
yes,
the liquidation value will be zero.
Yeah.
Because the recovery for secured financial creditor itself will be 20 to 30%. So there will be nothing flowing down to the operational creditor.
Because I want the audience to understand that once we say operational creditors should be paid, prior means entire amount what is due to them is to be paid, they will think. So that is why the clarification.
Yeah. Okay. Then the role of COC I have already discussed. Then the jurisdiction of AA, adjudicating authority and NCLAT. So the court says there's limited judicial review available to A within four corners of 30 subsection 2. It says NCLT has to check whether mandatory contents are there or not. Apart from that, don't interfere with the commercial wisdom of the COC. It also says that section 65, section 60 subsection 5 is the one section where left and right everybody was filing application. They said this section allows us to file application even before a resolution plan application is taken up by NCLT, right? That was actually delaying all the cases. So Supreme Court said, boss, that was not the intent of section 60 subsection 5. That what was given was in relation to cases against the corporator under CRP, not for delaying and all these litigations, spurious litigations coming to delay the CRP. So it should be avoided that these litigations which delay the CRP should not be taken up by NCLT before approving resolution plan. They spoke about secured and unsecured creditor. So this is, I think, the first case where very clearly it was brought down that all may not be equal. Till then, if you see NCLAT judgments, it was like there is discrimination. You are discriminating between operational creditor, financial creditor. You are discriminating between secured, unsecured. You are discriminating between first ranking secured and second ranking secured. Right? All those things really irritated the resolution applicants, and it set back a lot of resolution plans. So obviously, a secured creditor will be wanting more money because he has invested more and he has collateral, right? If you don't give him money, why will he vote for your plan? So you will have to give him more money. So this is the first case where this was discussed in deep, and the Supreme Court said all creditors are not equal. Creditors play a different role to a corporate creditor. Financial creditor would have played a bigger role, right? So it is very much possible for, it's not discrimination, there is an intelligible difference here. It is very much possible for a resolution applicant to classify them separately and give them separate amounts, right? And that cannot be said to be discrimination. It says that quite clearly secured and unsecured FC are differentiated when it comes to amount paid together with dissenting and assenting. So it says that it's up to the COC to decide on feasibility of the plan. COC feels there is no discrimination among the creditors, it approves the plan with requisite majority, then it's approved. NCLT cannot come in and intervene. Then constitution of subcommittee. In this case, there was subcommittee made by the COC to decide on affairs of the CRP process. So this Supreme Court said here that important things like approval of resolution plan, negotiation with RA, approval of plan, and major things like replacement of RP, all these things should be done by COC only. It cannot be delegated, right? But for administrative convenience, you can always set a subcommittee of COC having major voting right lenders, and they can take the negotiation with RA in the interest of other lenders as well. So it says it's not barred to do that, but main functions you should not delegate. And it spoke about guarantors, that plan will be binding on the stakeholders and guarantors. It spoke about claims importantly. It said that once a resolution plan is given, new claims should not be put up on the resolution applicant. Till how long will he keep sitting? And he should have a clear idea when he's bidding for the asset. He should know what are the claims, what are the assets, right? How much should I pay to each class of creditors? So new claims can't keep coming up. So that's why there should be end to that process. As per the law right now, you have to submit your claim within 14 days of public announcement, or you can submit up to 90 days. But as per NCLT judgments, you can submit up to submission of resolution plan. Then it spoke about utilization of profits made during CRP. So in this case, it was told that if a resolution plan had mentioned something about this, then action would have been in accordance with the plan. But there was nothing like that, so it will not go to the financial creditors. It upheld the constitutional validity of the
one more point here, Badri. Sorry
Yes,
for
sir.
interrupting.
Yes, sir.
The guarantees given by the ex-directors will be treated on a different footing.
Yes,
They
sir.
still are liable.
Yes, sir. So yes, personal guarantors can still be gone behind by the financial creditors. Then again the constitutional validity was upheld. Here also, this is the part where they said that 330 days, it cannot be mandatory. You cannot say that all litigation should be completed within 330 days, because that's not possible in our country, right? So they made it directly. Again, the discrimination part between OC, dissenting financial creditor, and financial creditor, they said it's all fine and there is no discrimination, and the law is quite clear. Then finally said it's up to the commercial wisdom of COC to decide what it wants to do, whether it wants to approve the plan or not. So this case is, along with K. Shashidhar case, these are landmark cases on commercial wisdom of COC. So somebody asks you commercial wisdom, K. Shashidhar, Maharashtra Seamless, and your SR Steel case. Then you have this Anuj Jain, IRP versus Axis Bank Limited. So here, I'll want you all to go through the slide. Okay. So this case mainly deals with how an RP should conduct preferential transaction review, which is 43, 45, 50, 66 section. Undervalued transaction, extortionate transaction, preferential transaction. So how an RP should conduct those. So procedures are given, right? What steps RP has to follow? What is preferential? What is undervalued? The court says that there is a difference between preferential and undervalued in the sense that there is no hint of intent given in the section for preferential transaction, but for undervalued transaction, the legislator has specifically put that intent should be there to undervalue the transaction. So all these sections were bit by bit, they were explained by the Supreme Court. And the look back period also. So somebody challenged that, okay, IBC came 1st December 2016, right? And how can you look back before that? Not possible. Supreme Court said does not matter. If you think like that, the entire object of this section will fail. If IRP has come in and IBC just started and the court just started and IRP has come in and the court says look back 1 year and 2 year for related parties, he has to look back 2 years whether IBC was there or not. Right? Then it explained what ordinary course of business is. It explained duties of, this is what I'm saying, 43, section 43, preferential transaction, how RP should conduct. That is written here stepwise. this is an important point. It asks whether lenders of JAL, which was the parent entity, whether they could be considered categorized as financial creditor of JP Infratech Limited, which was a corporate debtor. So the parent entity had some security interest in JAL's asset. By that means they wanted to become financial creditor. Now the court here very well laid down that financial creditors are somebody who play a parenting role, right? They nurse the corporate debtor, they are there with them since the beginning. Some creditors who play no role and just have security interest cannot be called financial creditors to the corporate debtor. They may be secured. They may be secured creditor, but they cannot be called as financial debt, and hence they cannot be financial creditor. So because of this judgment, lot of financial creditor were made secured creditors and they lost their place in COC. Then you have Swiss ribbons case. Again, it upheld the constitutionality of the code, and then it spoke about liquidation being the last resort, spoke about the preamble, right? Again, it says that the classification, different classification between FCN and OC are fine. Then you have this Babulal Vardarji Gurjar versus Veer Gurjar Aluminium Industries. This again is related to limitation. This is not very important. If you know BK Educational and if you know that other case we spoke about, it's good enough. Then you have K. Shashidhar. K. Shashidhar talks about commercial wisdom of COC. In K. Shashidhar, what happened was NCLT approved a resolution plan with 66% voting right. The voting percentage was 75% then, right? So this went to Supreme Court. Finally, Supreme Court said that when the law says 75%, NCLT cannot approve the plan as 66%. But it stressed a lot on commercial wisdom of COC. It said if COC has approved something, then that is the final call, and adjudicating authority should not get into COC's foot. Then you have Union of India versus Association of Unified Telecom Service. It's a very recent case. Everybody knows about the AGR dues Supreme Court case. So here, this ruling, as for IBC, it does not have so much because ultimately the court here said NCLT has to decide about these things. Whether spectrum can be subjected to proceeding of court, whether telecom service provider can set to be owner based on the right to use the spectrum. So all these things they have put on NCLT to decide. A lot of gray areas are still there, and this is the judgment where they've been asked to pay the AGR dues in installments. So you'll find those there. I think we've covered the Supreme Court cases. I'll share one more slide. I'll close this and share the other one. We'll do the High Court one. So again, don't worry if you feel there's a lack of time, because I've highlighted the portions, I made all the things in concise manner, and you can always have a look at it. Supreme Court was the main thing. You get a lot of questions from there. Now we will look at the High Court cases. We'll try to run it through as well. So it says that in Sri Metallic case, Union of India, right? Here the petitioner said that the IBC does not offer any relief for the corporate debtor, right? And the corporate debtor is losing his locus standi. The IBC is against natural justice, all those things same. However, you want to bring down a good legislation, whatever you can do, first of all, you attack on the constitutional validity of it. So here, the court was of opinion that IBC is silent on the process to be followed. That time, this is a pretty old case. So IBC is silent on the process to be followed, whether or not a party respondent has a right to be heard before adjudicating authority passes an order. The court also ruled that NCLT and CLAT were not bound by rules of Code of Civil Procedure, right? They can have their own rules. The court also stated that according to Section 424 of Companies Act, NCLT and LAT shall follow principle of natural justice. When NCLT receives a petition, both parties should be given an equal chance to be heard during a hearing procedure. So it's audio alterum partem. Everybody should have the right to be heard. It is required by 424 to determine nature of default as stated in application by financial creditor. The appeal to the wires to Section 7 fails under such cases. So the court said constitutionality don't challenge. procedure should be there. It's not there, but NCLT LAT should. It's already written in Section 424 of Companies Act that they should follow principles of natural justice. So it cannot be said that nothing is written in law and there is no relief for the appellant. Then there is Cushman versus Wakefield case. Here, challenge was made against registered valuation rule. So the petitioner was aggrieved by one notification in the registered valuation rule. It was alleged that the said notification impaired the right of petitioner by making petitioner ineligible from being a registered valuer. So some guy could not become a registered valuer because of the rule. He filed a case. Then the High Court held that the test of permissible classification, it is fully satisfied by the RV rules. While disposing the petition, High Court observed the objective and intention behind laying down the rule, impugned rule, is clearly to introduce higher standard of professionalism, specifically in relation to valuation. Valuation is very important in IBC cases, whether it's liquidation or CRP. So higher standard of professionalism is required. The impugned rule obviates the possibility of conflict of interest on account of diverging interests of associate entities, which resultantly undermine the very process of valuation, being one of the most essential elements. So they said the rules are fine. If you are ineligible under the rule, you are ineligible. Then you have Ultratech Nathdwara case, very interesting case. This was based on the GST department. So resolution process was going on, the plan was there. Then GST department made some claim. They said that first pay our dues, right? Then basically in this case, the High Court said that once the plan is finalized, and anyways you are an operational creditor, the government dues are operational creditor, you should have filed your claim form as per operational creditor, and you will get whatever money is owed to you as per your claim, as the resolution plan states. After that, you cannot bring and put something, and you cannot investigate, put a new investigation, and put a burden on the resolution applicant. It also spoke about preference of financial creditor or operational creditor, that banks will be paid first. See, as I said, the government brought this legislation to recover money for the banks and other stakeholders. So it can't stand in first in line and ask for money for my taxes or my dues, right? That's what the High Court said. You only brought the legislation. You want to first get the money. Not happening. Financial creditor will have preference over operational creditor. So it said that the creditors of corporate creditor will be injuncted from making any claim after approval of plan. So plan is approved, no more claims. It also says section 238, it overrides all other laws which are inconsistent. So that was also upheld.
So I think Badri should highlight to the students that what are the real important provisions in all these case laws. See, 238 often comes. 208 regarding code of conduct. Such things, I think they should concentrate. Then it will become easy. Yeah.
Right. Probably the participants can also look at the tabular sections which we have given. We have highlighted that also important section. So immunity to resolution professional, notwithstanding clause, the section 238. These are all very important sections. 238 is for limitation. Once you know the section, you will be able to correlate the judgments. Then you have this univalue projects case, where basically in this case there was some circular which said that NCLT circular which said that you have to file record of default. Record of default is maintained at information utility. So along with section 7 application, it has to be filed. So petitioner filed a writ petition under Article 226. So the issue was whether these things can be, circulars can be issued, whether NCLT could enforce the order retrospectively and adverse, because some cases would be there pending, right? And suddenly a circular comes that you put a record of default. Can that be done or not? So I've given both the arguments. You can read them later. So after hearing the arguments, the court said NCLT, LAT have been covered with powers to lay down their own procedure. However, such powers are subject to principles of natural justice. Such powers are also subject to provision of parent legislation, which is Companies Act and IBC. Rules will primarily be governed by its superior or parent legislation and only then its own rules. First, IBC. While quoting a Supreme Court judgment, inherent powers under Rule 11 do not permit NCLT to pass impugned order, right? So if NCLT says that because you did not file record of default, I am dismissing your application, that's not done. So this is what this case basically had. And after that, they removed that circular and they said it's not mandatory to file record of default. Then you have Tata Steel, BSL versus Union of India. This is a Delhi High Court case. So here in this case, again, Enforcement Directorate and CBI, some department wanted, after the resolution applicant has taken over, these people came with notices and started sitting in office and they started investigating all those things. So the question here was, have the resolution applicant taken over the corporate data, right? And whether previous offenses can be put on the new resolution applicant. So here section 32A was discussed. This was specifically brought in because of the Bush and Steel case, where the resolution applicants were frustrated after paying so much money. The older dues, the older faults of the earlier promoters were also brought on them. So they were really frustrated, and the government had to bring an ordinance and bring in section 32A. So that was discussed here. The judgment here was, if a prosecution has been instituted during CRP against the corporate debtor, it shall stand discharged from the date of approval of resolution plan. So during CRP, any proceeding started, stand discharge. Before
But-
CRP, if there was something, go under 32A, go behind the erstwhile promoters.
Yeah, only as well promoters action can be taken.
Yes, sir. Then you have PSL versus Jyotin India. Jyotin India is a Bombay High Court judgment. So here basically the issue was winding up petitions were lying in high courts, right? And there was an issue whether those should be transferred to NCLT or not. This is not a very important case from the angle of your exam, but they can, since they can ask anything, I have also taken that up. High Court essentially observed that there is a definite purpose behind legislator for creating two different petitions. Winding up petition is different, IBC petition is different. The legislator did not intend to transfer all petition to NCLT. Court further recorded the purpose of IBC and NCLT hearing petition is primarily to revive the company, whereas winding up petitions are for closing the company. So the court brought out distinction between these two petitions, and it said that it's not necessary all petitions have to be transferred to NCLT.
Correct.
Then you have Dr. Vidya Sagar versus IBBA, right? Application was filed under Section 6 for registration as an insolvency professional. That was rejected by IBBA. This question is there in the model question paper, right? So this application for registration was rejected by IBBA, saying that the insolvency professional is not fit and proper. Why she is not fit and proper? Because some FIR is registered against the petitioner and the charge sheet was filed as well, right? So what you have to remember is the Delhi High Court was of the opinion that if the trial court granted a plea for discharge, then the respondent IBBA could treat the petitioner's case as if new application has been made. So if the trial court has granted a plea for discharge, you can consider that as a new application and give them registration. High Court noted that the writ petition at this point was premature in a sense, and the petitioner was allowed to approach, the professional was allowed to approach the court after application is discharged by concerned trial court. Said, don't come right now. Let the concerned trial court take a call, then we'll see.
And one more thing,
Yes,
Badri.
yes.
Now we said like High Court, whatever winding up petitions and orders which are passed from there transfer to NCLT.
Yes, sir.
Similarly, under SICA, which are there before BIFR, Sikh Industrial Companies Act. So any scheme which was there under SICA will be treated as a resolution plan under IBC. IBC.
Okay. That's new for me also, sir.
Okay. That is it. Yeah.
Okay. So next is leave edibles and fats versus the tax recovery officer. So in this case, a writ petition had been filed in Hyderabad High Court by the petitioner against order of sub-registrar in Hyderabad. In that order, it had refused to register, the sub-registrar had refused to register the purchase of immovable property in the liquidation proceeding of VNR infrastructure on the ground that income tax department has claimed a charge on that asset. What happened is this company was in liquidation. Some asset was bought by some person in liquidation. He wanted to register that in their name. Then it came to know that the IT department, because of its dues, has claimed a charge on it. Hence, sub-registrar is not allowing registration. So this guy went and filed a writ petition. I could order the sub-registrar to register the sale of the property for benefit of petitioner, directed IT department to file a claim with the liquidator and get his money as per section 53. Then you have Axis Bank case, Delhi High Court. Here, the court went into defining the proceeds of crime. This related to PMLA Act. So the court went on to decide the proceeds of crime. So they may ask in exam, what did Axis Bank case, this case related to? Right? They will give you 4 confusing options. You should choose it was relating to PMLA Act for proceedings of claim. In this judgment, the court gave protection to bona fide third-party claimants to the extent that if the property at the time anterior to commission of claim they are able to establish that they took due diligence to ensure that asset is not a tainted asset, then the attached property can be released in favor of third party claimants. That means if a resolution applicant did its due diligence and it did not find any attachment because of the PMLA Act, it bought it in a bona fide manner, don't go behind that resolution applicant. The court interpreted definition of proceeds of crime in a manner which gave wide powers to the ED with respect to attachment and under PMLA, held that ED has powers to even attach clean properties when the tainted properties are not available for attachment. But if somebody has bought it bona fide, you should not go behind them. This is in Supreme Court right now.
Yeah.
I'll just share the other slide. We'll try to finish it as soon as possible.
Enclad, no.
Yeah, I think High Court couple of more cases where they, or I've written the number wrongly. There must be 10 or 12 cases. I'll send the slides to all the participants anyway. I'll open the enclad one. So here enclad first case is this was EARC Edelweiss versus Synergy Durace. So Edelweiss was not happy with the resolution. They said that because of some assignment of debt, Edelweiss voting percentage in COC has gone from 40% to 9%, and a better resolution plan should be given by the resolution applicant so that interest of all other stakeholders are met. Here, NCLAT held that commercial wisdom of COC prevails. They have approved that the plan with this majority, right? 91%. Edelweiss had 9% because of that assignment. Hence, this application was dismissed.
And incidentally, this is the first matter to be decided, no?
Yes, yes. Synergy to raise was the first resolution approval. Then you have SBI versus Anuj Vajpayee. So here, NCLAT held that secured financial creditor while opting out of liquidation process. So when he really he says, I want to enforce my security interest, right? He'll say, I'll sell my asset, I'll get my money. I don't need the liquidator sell. So when he wants to opt out of liquidation process, then also he is barred from selling the asset to a person who is barred under Section 29A. This is so that the asset by wrong means does not go back to the promoter again. So liquidator has to verify before permitting security creditor to realize security interest, whether whoever is selling to is barred under Section 29A or not. Then you have SKS Power Generation Chhattisgarh versus Nagarajan. So in this case, the appellant had lodged an appeal against interim order of NCLT Chennai bench, which allowed respondent in an application filed under 4345, which is preferential application, ordered the appellant to pay amount of 158 crores collected from corporate debtor. The respondent appeared and filed an affidavit in reply, pleaded that the appellant was the 10th respondent who had been ordered to refund the 158 crore, as the balance had to be paid by the corporate debtor. However, it was agreed that the challenge order was passed by means of temporary order without determining if application could be maintained. It was a temporary order. Appellant had pleaded the NCLT Chennai bench in the form of temporary order without even impleading and hearing the third party. So there was violation of opportunity of being heard. The NCLAT had set aside the interim order and held that challenge order had been passed by means of interim order without determining whether it can be maintained under 43 or 45, and referred the adjudicating authority to rule on validity of application first if it had not yet been determined. The appeal was hence granted. Then you have Exim Bank, Export Import Bank versus Aston Field. In this case, appeal has been filed by Exim Bank appellant against order of NCLT under Section 10. Again, this what I'll suggest is I'll take out those cases which are smaller, so we are able to finish most of the cases. You can just read the summary here. It says the court held here that shareholder has the right to determine whether to accept or reject a decision on insolvency proceedings under Section 10. So when you want to file a corporate voluntary insolvency, you normally go to shareholder, take their approval, and then you appoint an RP. So the court held here that shareholder has the right to decide that. and such right shall not be limited by a deed of pledge or any other instrument.
That
So
is,
you cannot limit that.
even if you had pledged his shares to some
also.
other creditor also, then also he still has the right to decide regarding IBC proceedings,
Right.
whether to go or not.
Right. Then you have State Bank versus Moses Bear Karamchari Union. Right. Here it was confirmed that the dues should be paid to workers directly. Right. So whatever dues like PF dues, gratuity fund, whatever should be paid to workers directly, it will not form part of liquidation estate. So I've written what is the challenge, what was held. I've given very detailedly there. Then you have Gammon India Limited versus Nilkant Mansions and Infrastructure. So in this case, Gammon India as an operating creditor filed application with NCLT, Mumbai bench, right, against Nilkant Mansions. The said application was dismissed on the ground that the same was not maintainable against partnership company. The appellant in this particular case brought an appeal before NCLAT, having been aggrieved. It was a case of appellant. So I've given the brief background here. The NCLT noted that a bill was levied against the aforementioned partnership company where the partners were corporate debtor. So, though it was partnership company, the partners were corporate debtor. Among other items, NCLAT held that since the balance is due from partnership company, even though corporate debtor is one of the partner or more than one of the partner, an appeal cannot be retained. So it said that you can file only against a person who is the corporate debtor.
Yes.
Here it's a partnership form whose partner is a corporate debtor, so the appeal is not maintainable. SC Sekharan, it talks about section 29A. So not much.
Yeah, we already covered this.
Covered. Then you have ERA Infra Engineering versus Predico Commercial Services. The issue before NCLAT was if CRP issued by NCLT and subsequent appointment of IRP and declaration moratorium on the basis of application under Section 9 Operation Creditor, was it proper as the Operation Creditor had failed to issue demand notice as required under Section 8. So in Operation Creditor CRP application, you have to issue demand notice in a prescribed format, right? So here it was observed that NCLAT held that adjudicating authority has refused to notice the above mentioned fact and necessary provision of law since the request was not complete and there was no remedy, no other way to remedy the defect. Order under the appeal cannot be upheld.
Correct. Demand notice is must.
Yeah. Then you have Ferraro Alloy Corp versus Rural Electrification Corporation. Here the question to be resolved was whether IBC under Section 7 can be sustained against corporate debtor without initiation of CRP against principal creditor. So NCLT here held that without initiating CRP against principal borrower, it is still available for financial creditor to proceed against corporate guarantor. As the creditor is also financial creditor, the IBC code, if you read the definitions about financial creditor, corporate guarantor is also financial creditor. So NCLAT said, even if you don't go against the principal borrower first, you can obviously go against the corporate guarantor first. Then you have Dr. Vishnu Piramal Kumar Agarwal versus Messrs. Piramal Enterprise Limited. This basically dealt with whether CRP can be initiated against a guarantor and a corporate debtor or a surety and a corporate debtor on the same set of claims. The court permitted the CRP proceedings against guarantor 2 and denied the argument against guarantor 1 as the borrower had confronted all the guarantors full sum arising out of same default. So what happened here is one corporate debtor, 2 guarantors, CRP going on is corporate debtor and filed against the 2 guarantors as well, right? So the NCLT said on the same set of claims, we cannot have different proceedings. Voice breaking. Is it okay now? Probably.
Yeah, now
network issue at your end, Pallavi.
No, when there are 2 corporate guarantors, you can, once you proceed against one corporate guarantor for the whole claim, then you need not go against the other one.
Yeah.
Because anyway, it's covered in the first
correct
matter.
Even the case 12 Export Import Bank, that also relates to corporate guarantor only. So here also NCLAT ruled that after economic court revoked the loan deal between the principal borrower and appellant, the borrower could not have default. There is no debt due and payable by principal borrower. It was held that the guarantor's responsibility existed only when the principal creditor refused to pay or refund the request. Appellant had submitted application. Furthermore, NCLAT acknowledged that since the IBC prosecution are permanent and lead to extraordinary and severe effects, this appeal will be counterproductive to respondent or guarantor. That's why the appeal was rejected.
No, but Badri, that is when the principal borrower is not liable.
Not liable. Yes, sir.
Then guarantor also is not liable.
Correct. So first you go as the principal borrower first. So Santosh Vasantrao Valokar, this case in essence relates to claims which are not dealt with under the resolution plan. So if a resolution plan is given by applicant, right, that is approved by COC, whatever claim is there will be dealt as under the plan. If something is not there, that will stand extinguished. Recently, we have a Supreme Court judgment on this, Edelweiss versus Gansham case. There also the same stand has been taken by Supreme Court. So again, this JSW case. So here again, it was said that whether after approval of plan, can ED attach the assets of the corporate debtor.
29A, 32A.
32A again was
so
upheld
these
here.
sections you have to remember.
Yeah. So sections are very important to understand. So flat buyers association versus Umang Realtek. Here the NCLAT took a practical approach, and here I think this was a case of reversal of CRP.
Yeah, what they've done is the promoters, because of whom actually it has come to this process, they can fund this thing and see that everything is completed. To that extent, they can infuse funds.
Right. So there was a reversal of CRP. A new process called reversal of CRP or reverse CRP process.
Now here CRP with the help of promoters only.
Promoters only. So the observations of Honorable NCLAT have been given here in very detailed manner.
Yeah, that's good.
So the order introduces the concept of reverse CRP. Dharmendra sir, I just like to know, I can still take up the NCLT cases if you can give me like 10 minutes. Dharam sir, are you there? Or if the participants are ready to wait.
Yes, sir. Pallavi says yes.
She's the only one sending message. Okay. 34 people.
Yeah, all others are saying. Venkatraman, Pandey, yeah. So let us go through NCLT also, no problem.
Right, sir.
Because it will be mostly repetition.
You want to take the first case, sir?
No, you can go ahead.
Right. So one is the Corporation Bank versus Amtech Auto. So these are all the cases which are given in your syllabus. But some cases I personally feel have become irrelevant also. So in this Corporation Bank case, application was submitted on behalf of COC under 65. As I said, everybody files case under 65. In order to designate resolution applicant to whom resolution agreement is binding as disqualified for intentionally contravening the provisions of the plan and failing to enforce the same. It was also prayed for restoration of company of creditors. So, and a further 90-day process will be given to RP to make another effort to settle the matter. It was also prayed that RA be stopped from making application in form of a fresh procedure. That means RA should not be allowed to again come into the process.
Correct.
The Corporation Bank as a financial creditor, earlier this some history has been given here. Mr. Dinkar was appointed as RP. NCLT held that a simple default in execution of plan within the time limit in the plan. An urgent appeal should be given to any member of COC or RP with the right to file a complaint before IBBA or central government with a request to file a criminal complaint on the ground that a deliberate and willful violation has occurred in terms of condition of plan. This case came because there was a lot of resolution applicants which promised something, gave a plan, routed away all other resolution applicants, and then they denied to pay. They said, "We are sorry."
Especially the Liberty House.
Liberty House, yeah, especially Liberty House Group. Right. So the NCLT said that there should be option to file criminal complaint with IBBA as well and with the central government as well. It was noticed from the order authorizing the resolution plan that out of 2 applicants, one highest value proposal was accepted by COC. It was noticed that there were 4 additional applicants who did not respond to the resolution professional. The bench therefore held that in view of purpose of the code and the rules laid down under the SR case, it was difficult to consider the prayer for commencement of fresh procedure for the resolution of corporate debtor. What it said is, there were 4 people who did not respond. 2 people gave bids, you selected highest one. So 6 people are there, no resolution came, entire timeline exhausted. So as per the code, we cannot give a fresh commencement here. In Supreme Court, we saw JP Infratech got a recommencement of CRP, but that was Supreme Court. Then you have Sterling SCG Infra versus Deputy Director, PMLA. So in this case, Sterling Infra, the appellant, it was the corporate data. It's a subsidiary of another company, Sterling Biotech. Sterling Biotech is a public company situated at Baroda, right? The CRP was initiated against corporate data by SREI Infrastructure. SBL Group had required more than 5,000 crores from banks and financial institutions. These loans had been transformed into NPAs. In addition, credit facility used by SBL Group to the tune of 8,100 crores were deemed to be fraud accounts. So ED began charges against the corporate data. As part of proceedings pursuant to PMLA Act, it attached certain properties. An application under Section 7 of IBC was filed by financial creditor and it was admitted. RP was appointed, moratorium was imposed. Request was made by RP to ED to revoke the attachment because RP has to take custody and control of the assets, as he was expected to take it, right? An application was filed in NCLT for a direction to release the provisional attachment. NCLT held that the annexation order of ED under PMLA Act was null and void and therefore have no binding effect. Bench also stated
again section 230, again section 238.
Yes, again section 2. The bench eventually ordered that the RP to continue take care of assets and monitor and comply, considering there was no attachment order.
Yeah.
Then you have Aircell Limited case. The question was whether telecom license granted by Department of Telecom under Section 4 of Telegraph Act can be cancelled because the latter is under CRP. So when Aircell went into CRP, can you cancel its telecom license? The NCLT observed that the resolution applicant would show interest in CD only if it hold license. What will a telecom company do without a telecom license? Since no other valuable asset is available to the CD, no applicant will show interest. License is therefore sine qua non for getting good resolution plan. Section 14, subsection 1, clause D also prohibits recovery of any property by any owner or lessor in possession of corporate data. The prohibition is also applicable to DOT. Use of license is akin to essential goods and services, without which it cannot run its telecom business. Hence, NCLT instructed DOT not to cancel the telecom license. Then you had GNB Technologies Private Limited. The corporate debtor filed application under Section 10, voluntary CRP, right, seeking CRP or liquidation. It submitted that it did not have any operation in 5 years. Its liability was 42 crores, did not have any assets. The NCLT directed liquidation without admission and appointed an appointment of IRP. Straight away ordered liquidation. There is hardly any possibility of any resolution plan likely to be received during first stage of CRP if initiated. 5 years you are not running business, you don't have assets. And thus it would be just and proper to put the corporate debtor under liquidation process.
So it is a unique case where CRP was given away and straight away liquidation was ordered.
Right. So this might come in the exam. Like
very important, very important.
Liquidation was ordered without going to CRP. Then you have a Videocon Industries case. So there were applications demanding and opposing consolidation of proceedings. So Videocon had a lot of subsidiaries, right? So there was one view where it was told that all these subsidiaries should be consolidated and there should be a consolidated CRP, one single RP, and then you will get good bids for the Videocon as a group. There was another set of lenders which did not want this consolidation to go through, right? The adjudicating authority observed that a blanket view is not possible to declare that the entire group is fit to be consolidated simply because they are connected by common management. Each unit or subsidiary should be examined on merits. Many factors need to be considered. This was the case which set out your CRP consolidation in India. There is no legal background here even till date. Only couple of cases. One is Jet Airways case, another is Videocon case where consolidated CRP has been done.
Correct. So for consolidation, this is the case.
So basically the court says if there is a subsidiary whose business is linked to the parent entity's business and these two cannot run without each other, it makes more sense to consolidate the CRP of these two so that whoever comes will get a value chain.
There is common control, common directors, common everything is there. No? 13 Videocon companies with common control, common directors, common assets. Yeah.
Correct.
In such cases, consolidation can be ordered.
Can be ordered. But if there is a subsidiary which is running good on its own,
then it will be treated separately.
then why should that subsidiary be consolidated? The lenders there will say, I'm running good, my exposure, debt exposure is low. Why should I consolidate with my parent entity which has multiple times debt exposure? My role in COC will get diluted. So it's important for participants to know the logic also, how it works.
So ultimately, this is important. Coexistence for survival.
Yes, yes. Then there is Adhunik Metallic Limited case. The liquidator filed application seeking clarity about treatment of claim received when the CD was supposed to be revived under resolution plan. The NCLT held that the claims received during the period can neither be insolvency resolution cost nor liquidation cost and hence cannot be accorded any priority over other dues. So it fell in a gray area. So Hammerley Textiles case, I have given a very detailed because it was a very big judgment. So I have given a very detailed slide here.
Mostly about 30, the resolution plan contents and all.
Mandatory contents of the plan, and whether how the compliance of section 30-31 is looked at by adjudicating authority. So it again talks about commercial wisdom of COC, that NCLT and NCLT should not interfere with commercial wisdom of COC. It is thereby submitted that requirements of performance, security, etc. are complied with. So the court basically ran through the resolution plan. It checked whether 30-31 were all complied. It gave a pass through to the plan. Then you have Coastal Power Projects, Coastal Projects Limited case. In this case, State Bank, SBI versus Coastal Projects, Kolkata NCLT had admitted CRP against the company. The name can be seen in second list of defaulters of loan on RBI website. The respondent company was referred to insolvency board by appellant for unpaid dues of 900 crores. SBI went against them for 900 crores. RP appointed to control the insolvency process, which is responded. The appellant company, which is SBI, appeared before the court asking bench to entertain insolvency petition against the firm under section 7. The cumulative cost of respondent amounted to 975 crores. Organization did not challenge the default number. Whatever outstanding was claimed by SBI, the corporate did not challenge it. At the last hearing, appellant's company's counsel told the court that the firm had been on the RBI list of defaulters. Justices were hearing the petition, and according to the respondent company, company's fund and non-funded facilities amounted to 4,000 crores and were restructured under a CDR scheme. So there was a list on RBI side where they were appearing. There was outstanding exposure of some 4,000 crores which were restructured under the scheme. Although the package has been introduced, the recovery of business takes time because of some internal external conditions and because of stress in the economy. The court approved the petition which was submitted by financial creditor for the commencement of corporate settlement process and also declared the moratorium. So here what we should understand is default is the main criteria. If default is there, right, principle of natural justice is there, the court will more or less just admit the application because their judicial review is very limited. Then you have Gujarat NRE court case where the liquidator sought direction of NCLT against secured creditor to either relinquish their security interest, means give away security interest, come under the process of liquidation, or to proceed again under section 52, enforce their right, sell asset and take their money, because they were not giving their decision. So liquidator had to file application to make them give their decision. Considering the fact that liquidation cannot be completed without cooperation, it directed that security interest shall stand relinquished. Actually, under law right now, if within 30 days financial creditors do not give intimation, it is deemed relinquishment. Then you have Jet Airways case. For this, the best way is to refer the judgment. I'll highlight the judgment, the important points. I'll make sure after this session, I'll get it circulated to all the participants. Then you have Kiran Global Chem Limited. Here the resolution professional sought permission to have access to GST portal to file GST return during CRP. So that is the status of resolution professional in our country. They don't get cooperation. They don't get their fees, right? They are threatened by operational creditors. Every single day somebody will threaten them. They need police protection. They need police protection to go to the plant site. They are not allowed to the plant site by operational creditor because those creditors are angry on the promoters. They don't understand the law or the process. So here the RP went to NCLT to get GST portal login and to pay GST liability. The NCLT observed that tax authority cannot raise an objection, saying since no provision has been made in GST or its offered to accept such account. So RP said, this is CRP, this is a new phase. So during CRP, whatever liability is there, let me make a new account. I will pay the liability. Before CRP, it's anyways claim. Should come as a claim form. So why should I pay that? So GST authorities are like, nothing is there in the act. We cannot do all these things, right? Again, the government which brought out the law, another department of the government is not letting the law run efficiently. So the NCLT directed authorities to allow corporate debtor to have access to portal, permit RP to file return for after CRP period without insisting upon past dues.
dues.
Yeah. Then you have Indus Biotech Private Limited. So here the issue was whether CD can be referred to arbitration while deciding application under Section 7. Under what circumstances Arbitration Act will prevail. So with respect to the first issue, bench while allowing the application under Section 8 of Act, so it allowed arbitration, stated that it is a settled law.
Special law prevails over general law.
Yeah, special law prevails over general law. Bench relied on decision of Consolidated Engineering Enterprise, where Honorable Supreme Court held that arbitration is a special law, right? Bench also referred to case of Hindustan Petroleum, couple of other cases, where it said that if arbitration clause exists, court has a mandatory duty to refer it to arbitrator. Then while deciding the second issue is under what circumstances will arbitration prevail over IBC? The bench said that it's needed to ascertain that there was a default. For the purpose of state assignment, it was required to resolve the dispute relating to valuation of share, calculation, whatever issues was going on between the parties then. The bench observed that it was not right admit CRP process against an otherwise solvent and debt-free company, and an attempt must be made to reconcile differences. It said this is a good company running good business, having good cash flows. So it will not be good to admit CRP here. And when arbitration is there, let the parties reconcile the differences in arbitration. Then you have Om Prakash Agarwal versus Tax Recovery Officer case. Here the tax department submit that income tax proceeding have overriding effect against other enactments and money attached by it are no more asset of corporate debtor. NCLT held that monies of CD lying in bank account shall be constituted to be asset of corporate debtor even if attachment order is passed. 178 of Income Tax Act has been amended to allow court to have the insolvency court to have overriding effect. So it ordered income tax to defreeze all the account. Then you have a PAL Infrastructure and Development Private Limited case, right? Here an application was filed seeking correction of voting result wrongly computed by IRP. That also happens. So voting was on proposal to replace IRP and appoint another IP as RP. It was submitted by 3 LRT associations that home buyers comprised of 72% of voting share voted for replacement with a voting share of 38%. In terms of Section 25A, if a proposal receives more than 50% voting share of FC in a class, same is treated as 100% voting share in favor of proposal. So if there is a class of financial data and more than 50% majority takes one decision, then it is deemed that 100% have taken that decision. However, IRP did not file an application for replacement. He rather raised objection to application made by FCs for replacement. Considering the facts, NCLT held that no further inquiry is required and allowed replacement of IRP. Then you have Om Paseco Rail Products, 2019 case. In this, it was held that notification issued by central government increasing the threshold limit from 1 lakh to 1 crore. It was prospective. Therefore, it will not affect whatever petitions were pending at that point of time within the NCLT. Am I right, sir?
Yeah, correct. It is prospective, not retrospective.
Then you have Chemisol Additives Private Limited, right? In this case, again, it was sent to arbitration by rejecting a Section 9 application. So here the court felt that prima facie it appears to be a solvent company. So whenever NCLT feels it's a solvent company, good business model, cash flows, or unnecessarily why to push this into CRP,
I think Badri,
suggest mediation or arbitration.
there can be an exercise for all the people who are participating that common topics they should list out, whether it is NCLT, NCLAT or Supreme Court under one heading and then see which are the cases.
Yeah.
That will be good exercise for them. Like all arbitration matters, they can put at one place, income tax under one, Section 29A under one, like that.
Yeah. Then you have Edelweiss versus Bharati Defense. This is the last case they have on the syllabus. So here the NCLT ordered liquidation of Bharati Defense, the respondent company, and refused resolution proposal of Edelweiss. In this order, Mumbai NCLT was of the view appellant had not issued a realistic and feasible strategy to handle affairs of Bharati Defense. So Edelweiss did not give a good plan, which will show how it is going to run Bharati Defense. In the order, 9 crore was proposed to be paid by appellant's plan against the dues of 187 crores against operational creditor. They would also be charged in a staggered way. And the new management would settle the sum and the length of payment for each operating creditor. That means they'll fix when I will pay each operational creditor. In addition, Edelweiss proposed to pay 1,124 crore in a staggered fashion to financial creditor, to whom it was 11,000 crores, indicating a 90% discount, only 10% recovery. The appellant company, who had received loans from lenders from Bharati Defense, retains 83% of voting rights in COC. In 2017, Asset Reconciliation Company had referred Bharati to bankruptcy. Approximately 95% of lenders approved the Edelweiss resolution. Bench was of the view that Edelweiss scheme suggests that 35 crore be used as cost of CRP before repaying other debts. The bench also expressed its concern that huge fee paid by resolution professional and his team of few individual, even though the organization had a large workforce, RP brought in his own lot of professionals. So a lot of CRP costs accumulated. The bench was also of the view that monthly fee paid by RP and his team approximately 80 lakh, while the monthly fee of 50 employees is 1.5 crores. So RP took 80 lakh, while employees, 850 employees only had 1.5 crores cost, which is indicating a high fee for RP and his team. The bench considered the national significance attached to the product line to the consumer, specifically Ministry of Defense. Bharati Defense makes defense equipments, and customers are basically Ministry of Defense, Coast Guard, and Customs. The bench had ordered liquidator to try and sell the corporate as
a going concern.
So if you sell by piecemeal basis, you will not get anything. So looking at the national significance, it said you sell as a going concern. So that's all on NCLT as well. So what I'll do is I'll send out these slides, highlighted ones. I'll send out a couple of judgments which I've not covered in the slides because those have to be read from the judgment. I'll send it out to Mr. Dharamji and he can forward to all the participants. I ran a little late. I took 20 minutes more time. I'm really sorry if I delayed the dinner of participants. And thank you. I delayed Venki sir's dinner also. He eats early.
No, today my diabetic levels have come down by 100 points, so I'm happy.
Mr. Vikas ji, please on your video also, please. Vikas.
Venki sir is very busy. Insisted. I told him on Sundays, so he will never come.
बद्री सर बहुत अच्छा, मतलब ये सर बहुत डिफिकल्ट टॉपिक होता है कि कोर्ट ये जजमेंट्स को कंट्रोल करना सर.
Yes.
और पार्टिसिपेंट का भी मैं व्यू देख रहा हूँ तो फीडबैक बहुत अच्छा आ रहा है, तो बहुत अच्छे तरीके से सर हैंडल किया हमारे ये, मतलब कह सकते हो कि हमारे ही मेंबर ने हमारे ही प्रोग्राम में ग्रीमा ला के रख दी.
थैंक यू फॉर कॉलिंग.
नहीं सर जी, मैं हमेशा कहता हूँ स्टडी सर्कल इज नॉट ए माई प्लेटफॉर्म, नहीं आवर प्लेटफॉर्म, दिस इज फॉर मेंबर. और मेंबर आए, मेंबर अपने मेंबर्स के लिए ही है, मेंबर्स की फीस होती है, मेंबर के CPRs होते हैं, मेंबर के प्रोग्राम होता है, मेंबर ही अटेंड करते हैं. वी आर ओनली कोऑर्डिनेटर. ठीक है. थैंक यू सर सी बद्री जी, बहुत अच्छा लगा. And CA Venkatesh sir, thank you sir today moderating this program. बहुत सर आपका टाइम जो हमने आज मॉडरेटिंग के लिए. हेलो.
It's my pleasure sir, it's my pleasure.
हाँ सर. तो सर कल के जो हमारा कल का जो केस स्टडी है प्रोफेशनल एथिक्स पे, तो सर उस पे हमारे स्पीकर भी रहेंगे. और कल शायद मॉडरेटिंग शायद एस बद्रीनारायण करेंगे, तो हम भी साथ ही, मैं भी साथ ही होता हूँ सर. बद्री जी जब भी कहोगे हम तो वीडियो ऑन करनी होती है.
ठीक है सर.
ठीक है. तो हाँ, तो सर बहुत अच्छा लगा सर आपसे. सर पहली बार सर आपसे इंटरेक्शन हुआ हमारा.
मुझे भी ऐसे अच्छा लगा.
हाँ, और हमारा प्रोफेशन एक ही है सर, CA है, तो हम एक कॉमन प्लेटफॉर्म पे काम कर. मैं भी कंपनी सेक्रेटरी हूँ सर बाय प्रोफेशन, चार्टर्ड अकाउंटेंट भी हूँ. तो पहले चार्टर्ड अकाउंटेंट, बाद में कंपनी सेक्रेटरी.
अभी तो एवरीबॉडी इज एन इंसॉल्वेंसी प्रोफेशनल नाउ. ओके.
Now sir, all are the same platform sir.
Yeah.
और लीगल कंप्लायंसेस में देखो तो कंपनी सेक्रेटरी का रोल बड़ा है पिछले 2 सालों से, बहुत अच्छा लग रहा है क्योंकि मोदी गवर्नमेंट के आने के बाद कंपनी सेक्रेटरी का रोल बड़ा है। तो मिस्टर सी विकास आनंद सर हमारे साथ है गोरखपुर यूपी से। ही इज लीडर ऑफ आवर श्रीफोर्ट सीपी स्टडी सर्कल, तो काफी हमारे साथ इंटरेक्शन में रहते हैं और काफी मेंबर्स जो है इनके कंट्रोल में भी हैं। तो सीए विकास जी, मैं आपसे रिक्वेस्ट करूंगा कि आज के प्रोग्राम पे फीडबैक दीजिए और उसके बाद हमारे आज के गेस्ट स्पीकर और मॉडरेटर्स ये वेंकटेश सर, सबका धन्यवाद करिए और जितने हमारे मेंबर आज अटेंडी हैं और यूट्यूब पे हैं उनका भी धन्यवाद कीजिए। और सिर्फ सीए बद्री जी, आपसे रिक्वेस्ट है कि सर मेरे को ये आप अपना पीपीटी मेल कर दो, तो जो कि मैं सब मेंबर को, काफी मेंबर्स का मैसेज आया व्हाट्सएप पे चल रहा था,
बनाया तो इसके लिए उन्हीं को देना है।
हाँ, और इस प्रोग्राम की वीडियो सर हमारा सीए और यूट्यूब चैनल है उस पर रिकॉर्ड हो चुकी है, तो वहां से कोई भी देखना चाहे तो मेंबर देख सकते हैं। तो विकास जी, माइक इन योर हैंड नाउ।
यस सर, गुड इवनिंग सर एवरीवन। और बद्री सर, आपने बहुत अच्छा बोला और केस इतना अच्छे से डिटेल में बताया आपने कि बहुत कुछ समझ आया। और इतना अच्छा केस में किसी का कमांड नहीं होता, सभी लॉ जानते हैं, लॉ पढ़ाते हैं और लॉ को ही एलाबोरेट करते हैं, लेकिन केस ऑलरेडी इतने ज्यादा पेजेस में होता है, एक केस पढ़ने में तो हालत खराब हो जाती है। आपने कितने सारे केस पढ़ा दिए हम लोगों को 2.25 घंटे में। बहुत ही अच्छा पढ़ाया सर आपने और बहुत ही ज्यादा उम्दे तरीके से सारे केस को समझाया।
थैंक यू।
हाँ सर, और दूसरी चीज है कि एक एक केस में इतना डेप्थ में बताया और फिर मॉडरेटर सर ने भी बहुत अच्छे से उन चीजों को और डिकोडिंग किया, हम लोग को और चीजें जो माइंड में आ रही थी वो सर ने हम लोग करना पड़ा।
वेट कर रहे थे कि कब मैं चुप हो जाऊं और फिर वो ले लेते हो, मतलब पूरा सेशन वो बोल लेते हो उनको।
नहीं सर, आपने बहुत अच्छा बोला और हम लोगों को बहुत कुछ सीखने को मिला। केस तो मैं पढ़ता भी नहीं था, मैं भी पढ़ाई किया था लेकिन छोड़ दिया था बीच में पढ़, क्योंकि ये 10 साल पुराने सीए के लिए ही वो है, इस कारण से सर मैं पढ़ा नहीं, किताब उताब तो रखा हुआ है बट छोड़ दिया फिर। लेकिन आपने बहुत अच्छा बताया सर, क्योंकि ये क्या है ना, आईबीसी एक लॉ नहीं है, एक कोड है, ये सभी लॉ का मर्ज रूप है। और जब जो चीज मर्ज रूप है मतलब हर लॉ का पॉइंट्स इसमें इंपॉर्टेंट चीजों को कंसिडर किया गया है, जिस कारण से जो है हर चीज का फिर नॉलेज होना है, क्योंकि यहाँ पे आके हमको कंसोलिडेटेड नॉलेज चाहिए, कंसोलिडेटेड चीजों को आउटपुट देने के लिए या रिजल्ट देने के लिए, एनसीएलटी पर जाने के लिए हर चीज का लॉ हमको कंसिडर करना पड़ेगा, चाहे टैक्सेशन लॉ है या कंपनी लॉ है या कोई भी लॉ, लेबर लॉ है, फाइनेंशियल लॉ या कोई भी। तो सर आपने बहुत अच्छा बताया सारा बहुत अच्छा लगा सर।
श्रीफोर्ट सर्कल कभी भी मेरे को बुला ले सर, मैं पहुंच जाऊंगा। धर्म जी, आप
मैं नंबर ले लूंगा, कोई भी दिक्कत होगी आपको परेशान करूंगा थोड़ा।
आईबीसी एनी सेमिनार यू वांट मी टू टेक, आईबीसी ऑडिट ऑलवेज अवेलेबल सर।
थैंक यू बद्री जी।
हाँ थैंक यू सर। और वेंकटेश्वर सर ने भी बहुत अच्छा चीजों का एनालिसिस किया और बताया सर, जो चीज हम लोग के माइंड में आ रही थी वो सर ने ऑलरेडी पूछ लिया, इसलिए हम लोग को ज्यादा परेशानी नहीं हुई। सर हम लोग के बिहाफ पे ही सब कुछ पूछ ले रहे थे, तो हम लोग को लिखना भी नहीं पड़ा, पूछना ही नहीं पड़ा, बस आसानी से अच्छे से पढ़ाई करनी पड़ी, वही अच्छे से कर ले, अच्छी बात है। सर ने तो ऑलरेडी बहुत कुछ चीजें हम लोग को सिखाया। थैंक यू सर, थैंक यू, बहुत अच्छा लगा सर और बहुत ही लर्निंग था, बहुत ही सबके लिए हाँ नॉलेजफुल रहा सर, और इंटरेक्टिव सेशन भी रहा, शुरू से अंत तक हम लोगों ने बहुत कुछ सीखा। और बहुत कुछ ऐसा हुआ बीच में कि थोड़ा सा चले इधर चले, लेकिन आपने इतना अच्छा चीजें बताया कि फिर आदमी हट नहीं पाया वीडियो से कि मान लीजिए अच्छी चीजें आदमी सीखता है और इंटरेक्टिव रहता है ना, तो आदमी हटने का भी कोई जरूरी काम आता है तब भी नहीं हटता है, चाहता है कि पूरा पढ़ ले थोड़ा सा किसी तरह से, फिर देखा जाएगा 1 घंटे बाद 2 घंटे बाद।
थैंक यू सर,
थैंक यू वेरी मच, थैंक यू
वेरी नाइस वर्ड्स फ्रॉम बोथ ऑफ यू, थैंक्स अ लॉट।
और मैं थैंक्स कहना चाहूंगा सीपी स्टडी सर्किल के बिहाफ पे भंडारी सर को, बहुत अच्छा लेक्चर लिया सर, और शेयर कर दीजिएगा पीपीटी, जो सभी के लिए फायदेमंद भी होगा।
बिल्कुल।
और वेंकटेश्वर सर को भी थैंक यू सर, थैंक यू। और सभी फेसबुक यूजर्स और यूट्यूब यूजर्स जो भी हम लोग साथ जुड़े हुए हैं, सबको थैंक्स कहना चाहूंगा कि सभी के कोऑर्डिनेशन से और कोऑपरेशन से ही सब होता है अच्छा, और सभी मेंबर्स यहाँ पे अपने इस प्लेटफॉर्म पे सभी सीखते हैं, और जो अच्छा जानते हैं वो स्पीक भी देख करते हैं। स्पीकर भी हमारे यहाँ सर ने बहुत अच्छा अपॉर्चुनिटी दिया, नया हो या ओल्ड, जिसको बोलने की इच्छा हो आके अपना थोड़ा लर्निंग दे भी सकता है और ले भी सकता है। ये बहुत अच्छी चीज है सर, धर्म सर के अंदर जो चीज हम लोगों ने सीखा बहुत। जी सर, थैंक यू सर, थैंक यू।
Thank you, Vector sir.
Thank you,
Tomorrow
thank
we
you,
will
thank
meet
you,
at
thank
the same time.
Yeah, tomorrow 6
Thank
o'clock.
you, Badri
Right.
ji.
Thank you, sir.
Okay, sir. Thank you, Vikas. Thank you, sir. Thank you.
Thank you.